I'm sorry.
However, since this court finds the present petition is under Article 227 of Constitution of India, it is observed this court has no authority to grant relief as prayed for by Mr. Acharya. It may be simply observed parties are to undertake any such exercise if so advised. Coming to the merit of the present case, this court finds sufficient force in the submission of Mr. Nanda, learned senior counsel, through the legal provisions taken note herein above. Considering the provisions at Rule 6 of the Rule 1996 and Section 24 of the Odisha Electricity Act, this court finds the Industrial Tribunal did not interpret them correctly. As a consequence, this court finds the award contrary to the legal provisions taken note herein above, thus not sustainable in the eye of law. In the result, this court interferes with the impugned award at annexure 11 and sets at the same. The repetition succeed, but however, in the circumstances of the case, there shall be no order as to cost.
I agree.
Item number 2.
It is in the above background of the matter, in view of the legal position that stands as of now, considering the pleadings and contentions of the respective parties through their statement of claim and written statement, and also looking to the exhibits in the course of industrial adjudication, this court find decision in 1997 for SCC 257 referring to the decision in the case of Bangalore Water Supply and Sewerage Board doesn't support the case of the petitioner. It rather supports the case of the opposite party herein, thereby supporting the impugned award herein. This apart, the other two decisions taken note herein above have also clear support to the case of the opposite party, and the findings of the Labour Court are thus well supported by the propositions of law settled through all the above decisions. This court, in the above background of the matter, finds the adjudication of the matter by Labour Court to be just and proper in refusing to entertain the reference, thereby requiring no interference by this court in such award. Read petition thus stand dismissed. However, there shall be no order as to cost.
So, order sheet the petition. Order sheet, order pronouncing.
Order sheet clear kartala.
I agree.
For example.
Item number 3.
In Considered opinion of this court, no case has been made out by the petitioner licensee to interfere with the findings of the ombudsman, being the competent authority technically to analyze the technical aspects of the pleadings of the parties. Therefore, it is held that this court cannot substitute the finding of the ombudsman without any material being brought to dislodge the findings. In view of the above discussions, the writ petition fails. The order passed by the ombudsman be complied with forthwith. In the facts and circumstances of the case, there shall be no order as to costs.
I agree.
Item 4.
In view of the above discussions, the writ petition is dismissed, being devoid of any merit. The order dated 30/12/2019 by the Consumer Grievance Redressal Forum at Jaipur, Koraput in Consumer Complaint Case number 151 of 2019 is upheld and shall be implemented forthwith. In the facts and circumstances of the case, there shall be no order as to costs.
I agree.
Next addition item 5.
Mr. Tripathi,
Can I make a
Mr. Das, by now probably we have already settled almost all requirements in this side. Therefore, after vacation, please assist the court by simply saying this is covered by.
But I have more of the basic transfer brief asla. जो transfer brief asla setik mo bagare se
No, that's right. That's right. But you now get
I will say.
at least a way forward rather.
And to be honest, how many of you have cited both sides? You, Mr. Rajguru Mahapatra, Mr. Vikas Jena, Mr. Das. How many of you have cited any decision and assisted the court? Apart from Kamdhenu Agro, Mr. Das, that has become his favorite chant, like kind of. He cites it as a mantra almost. Kamdhenu Agro. But somehow, actually, I think at this level, when we're taking up it at the level of a high court sitting in 227, 226, better kind of, so that at least this court has endeavored. Thanks to my lord for citing that, asking me that whether I have seen that decision, and thereafter perhaps it was a turning point. We should not, we have to maintain that.
We update every date.
And after your lordship judgment that
Every date. Some
recently come.
decisions are coming in live law, some decisions are coming in bar bench. Those are very instantly coming. Today something is passed, tonight there is something there.
And because of your
And
lordship.
the matters are pending since long also. That is other part, other aspects of
16,
it.
17, 18 matters are still pending on these issues. And who is at loss ultimately? The electricity department, parties, the consumers are enjoying. If you have to get
Ultimately,
something,
we
get
are-
it.
And in any event, any refund granted by GRF and ombudsman, confirmed by ombudsman, you are not granting.
And see, if you would
And
have,
they are not also coming to oppose.
if you would have complied those orders, then you could have improved your standard of providing the measures in the meantime. Because you went on challenging those things for 6 years, you are not improving yourself. Right? Who asked you not to put estimators like one side? Consequentially, transfer loss. See, both are consequential. You could have put a very well, as per the agreement, you could have put an estimator. Then gone for transfer loss. Nobody prevents. Because condition prevails. So, upon the kahar loss ultimately. Right, all right.
And it is a technical issue. Can you have a judicial solution to that? आपको estimator मिलू नहीं. आपण every time आछन दी कोर्ट को. से कहले हम estimator लगेलु ने आपण agreement 4 मास रे estimation न लगेले. आपनकर HT रे संग संग सीडी पके चढ़ी जिवे.
कोन करिए.
आपनकर HT रे संग संग सीडी पके चढ़ी जिवे.
कोन करिए.
आपनकर मेन 11 kV line shutdown पे आपनको प्रोसीजर टे भाबो.
Procedure. There is a procedure.
Permission.
You have to take a permission.
You have to take
आपनकर 220 line कला बेलकू आपण परमिशन नै कि ये होची.
permission, notification to general public that this line will be shut down for this period to this period.
33 and to 11. You have
All right. Yes, now.
My lord, I mean, pardon, my lords. My lord,
Yes,
item number 11, my lord, today morning I'm not getting the file. My lords, kindly take up after vacation, my lords. That is the difficulty, my lords,
confident that you will take up.
No, I thought, my lords will take up. So that
That my lord ensures that once it is listed, it has to be heard and finally heard. So at least I have been trained. By now I am trained.
Mr. Mishra, this is a special assignment. Therefore, I will not leave after vacation. You make
No,
it sure.
definitely not. Any date.
Special assignment. Some bench has declined to hear that, and that has been sent here.
I know that.
The 11 go after vacation for a second week after the opening. Date they know.
DPO obliged.
Interim order is pending to continue. At adjournment on the request of the council for fixing. Yes, item 5.
Item 5, Lord, I have summarized the facts and submitted a written notes, Your Lordship. Here is the question, the order of the GRF that has been complied with. But question is that the finding of the GRF on a remand proceeding of OERC, that is stand in the way. Only that line, because
But if order is already given effect.
order is given effect. But if that,
What is the purpose of remand? Where is that order?
Millard, if page 72,
Page
72, Millard. The wrong recording of facts, that is creating a new litigation.
Second 9464 of 2009.
Is it a single brief? Single brief. Single brief. ठीक. This matter was there yesterday.
Millard, you'll also had this matter and call for the down PC number. The earlier petition.
You know the reason. The order of the earlier division bench
Yes.
is very specific that you comply.
No, that has been complied with.
So you have
So
complied.
then what is there
Then
to be?
time
I mean,
possible.
adjudicate कौन करिबु?
No, only खाली गोटे
आपण
कथा होची.
question of law open रहो आपण
अन्य जो केस आसीबो सेठी डिसाइड हो. Look for the submission of Sri
এই লাইনটা রইলে আমি বলতাম
Tripathi.
প্রিজুডিস.
Sri Tripathi. The majority part of the direction of the GRF has already been complied. Therefore, virtually there remains nothing to be adjudicated except some observation of the GRF haunting the petitioner
On a remand. On a remand.
on the reminder to the ombudsman.
Of the OERC.
To
डेटटा कोन आपण
That
OERC.
annexure 7,
डेटटा
annexure
कहि दियो तू
Page
annexure 11.
11
Page 72
Page 71, starting from annexure 11, the relevant portion, page
by
70.
the order of the
The line, the petitioner has deposited the requisite amount for installation of the ST metering unit, but the respondent failed to do so. But this is contrary to the pleadings. Say gote line he creating problem.
Line?
The last but one paragraph.
Yes.
The petitioner has deposited the requisite amount for installation of a ST metering unit, but the respondent failed to do so. That is contrary to the pleadings.
Okay, all right. Yes, the last word, one para. Yes, the observations in the last word, one para, page 72, haunts the petitioner, which may be creating trouble in future. For there is already compliance of the GRF order by the Annexure 11. This court finds there is no issue in entering into such controversy at this level. However, observe such dispute, if arise in future litigations, will be kept open to be adjudicated there. With this observation, the petitioner stand before.
Problem.
Brief sangere rahibo.
For admission item
Feri
6,
dabo. Section ko feri dabo. Sir, ita nela WPC 9464/2009 called for reference purpose. It's detached. He released from this file. And also bandi roki debe.
item 6, for admission item 6,
My lord, on behalf of Mr. Phalguni Mahapatra.
On behalf of
Mr. Phalguni Mahapatra.
हाँ
Next money after vacation.
हाँ माइक क्या करते
Hajur after vacation. Then they are correct medical judgment. They are heart case.
settle the issue in the question. All right, there is request for on behalf of Mr. Phalguni R. Mahapatra for taking up this matter after vacation.
My lord, I am filing the application for substitution of TPNODL. Substitution.
एकाथरे से दिन नबाओ
Box file को देकर.
हाँ
I will file it in the box.
okay all right you are still continuing in this
Yes, yes.
okay that is miss case number
Number ही नहीं आमो करी के आनी चाहिए आज
this court I will, okay this court even though adjourn the matter main proceeding to after vacation finds there is there is filing of press miss case bringing in change in the petitioner side. The registry directed to register the same. Finding genuine request, this court allows this application. Amended post title file of registry directed to set the brief in order.
Connected subsequent
दे
all same order.
No sir, आमे दीटा 300 तो 20038
One by one.
एटा होची 20039. I am the petitioner in those cases.
Right. So we are taking up in the first case.
Yes.
20038 re I agree.
हाँ.
All right. Okay, there is request on behalf of the Phalguni Mahapatra. Matter stand adjourned to after vacation. So second week or reopening the list. Yes. Next case, Remis case.
20039.
Disturb करंतु बसंतु टी
20039.
Oh, that is already there.
Yes, my lord. With
20039 re what is the miss case?
sir, say what a substitution of TPNODL in place of NESCO.
Kain darkar. Oh, acha. The copy देइछे तो
Dita copy देइछि.
data copy देइछे अछि the other set is there. Okay, all right. Yes, same order of
Same order.
yes. Here also Phalguni Rajguru Mahapatra 6 time posted to so and so. Then third case,
Third case is by Raha.
there is a third case
By Rajguru Mahapatra, my lord.
you have not filed.
No, no. Third case रे ମୁଁ no ସେଟା
Petitioner ଅଛନ୍ତି ସେ ଆଣିବା କଥା
ସିଏ କରିବା କଥା.
के आनिबा कथा
Amendment करिवे बुझ पड़छन
all right after vacation कर दोछु हला you take instruction you have to bring the new party otherwise this matter goes
Yes.
all right we can
Item 7,
third case ta khali adjourn yes
May I please, Lordship? As per your Lordship's previous order last order, the newspaper publication, my lord, I made and the 3 copies of the newspaper are on record. So that's for the purpose of service of notice on opposite party number 9. And I think despite the publication non appears today,
995 was the date of appearance
yes.
I would a week doba I would a week doba
As your Lordship please.
yes this is a notice on the association
On the association, my lord, there is no such association in fact. They are all temporary employees of a outsourcing
that's right
agency.
but one address was given when
that's
the representation was made
Yes.
but that address is no more available
No more
because there is a district change in the
Yes, my
meantime
lord.
consequently we directed to take out fresh
Lordship is
notice by way of paper publication
Lordship is correct.
now the date was fixed to 9/5 they might be arranging we don't know let us wait for one more week means after vacation
My lord.
okay the pursuant to direction of this court dated (26/4/23). There has been paper publication bringing in notice as in respondent number 9,
It is opposite party number
opposite
9.
party number 9. Paper consequential paper publication is also filed in 2 sets. 3 sets, 3 copy deychen in 3 sets.
3 copies, my lord, the
Date
registry
of
said that
appearance
3
is
copies.
found to be fixed through the notification, paper publication as 9/5/2022. Hardly, nearly 1 week being passed, this court find it appropriate to provide 1 more week at least for appearance of such opposite party. As a consequence, this court direct this matter to be listed after vacation on so and so October, second week June. Second week June, date उड़ा देखिए कि संग କଥା ହେଇକି କର ଗୋଟେ ଦିନକୁ 5ଟା matter ରୁ ଅଧିକା ରଖିବ
ଆଜ୍ଞା
interim order is there
Interim order is there.
yes on
The
interim
last order shows there is an
interim
on
order
interim order.
till next date all right it is allowed to continue
Yes.
item 8,
Obliged.
in this matter of 2020 nobody is showing interest on behalf of the petitioner to pursue the litigation. Sri Das
The
counsel
order of the
appearing.
ombudsman has been challenged,
OP number 3 OP3
my lord.
for present for OP3 is present in court are dismissed for non-prosecution.
item 9,
Yes, have you brought the change in the cost title
Yes, my lord. I filed the cost.
already there
Yes, my lord.
or that application is pending?
Yes, my lord.
Okay, all right, it is allowed. Yes, what is the case? Have you verified the case along with the decision of this court?
Not one, sir, my lord.
We have already tasked all
Yes, sir.
subjects.
Yes, my lord. Recently.
What is the you challenge the order of the
my lord,
ombudsman?
GRF, my lord.
GRF. After the ombudsman proceeding is over or before
Hmm.
ombudsman proceeding is undertaken?
Before, my lord.
What was the direction of the GRF?
My lord.
What is the impugned order here?
Yes, my lord. That, my lord, there is a, my lord, SC line, the lordship go to
What is the impugned order?
page 43, my lord.
Answer
Annexure 9, my lord.
9, page
Nine.
36. It starts at
Page
36.
43, my lord. Annexure 9.
Hmm.
The OP,
Just before reading the concluding part, first place the claim of the claimant there, the consumer there.
that is, my lord. That is answer 6, my lord.
Yes, no, you can read through the GRF order you must have taken. Yes, now
Yes,
come
yes,
to
yes,
page
yes.
39.
Yes, my lord.
Come to page 39.
Yes, my lord.
Agreement enclose करचंती agreement हमर general trend agreement enclose करू नाहंती करचंती agreement टा
Page
Standard agreement.
page 14.
Page.
Standard agreement. Yes, 39 re paduntu.
Yes, my
Claimant
lord.
claim is quoted. Take a
My lord,
note
page,
there.
page 14, my lord, answer 1, my lord.
That is their application.
My lord, that is agreement, my lord.
No, come to the claim of the
My lord,
consumer.
my lord.
For the
Yes, yes.
agreement will go definitely.
agreement is a matter of
My lord, the claimant pay for, my lord,
Ah.
para 13, page 39, my lord.
Yes,
Page 39, para 13, my lord.
yes, read.
My lord. The complaint has prayed for the termination of a standard agreement for supply of electricity dated 26/10/2016
Hmm.
to direction of opposite party to revise the bill change upon the complaint since 03/12/2016 till the latest bill. 3. Refund of the amount which has been paid by the complaint without utilizing the electricity during those period in terms of agreement along with interest at the rate of 18%. 4. Direction of opposite party to refund the SD of complaint lying with opposite party in the lieu of agreement. My lord.
So these are consequential.
My lord. Your lordship.
So in the event the second prayer is allowed,
Yes,
then
my
the standard agreement has to be changed
yes, my lord.
and the consequential deposits have to be refunded.
My lord.
Okay, then what was the term of agreement?
Yes. The term of agreement, my lord, answer 1, my lord.
All these prayers have been allowed.
Yes, my lord, all prayers are allowed, my lord.
OP is directed to make the termination page 43.
The direction of the form 43 page, my lord. The opposite party is directed.
To make
The opposite party is directed to make termination of agreement after completion of 2 years from the date of initial power supply as per clause 16 of OERC Dispute Code 2004 and to settle the final bill of the
Therefore,
petitioner.
there is allowing. First prayer since allowed, all consequential prayer automatically follows.
My lord.
So there is a direction for bringing change in the termination in the agreement.
Yes, my lord.
After completion of 2 years from the date of initial power supply clause, distribution 2000, and to settle the final bill of the petitioner accordingly.
My lord.
So what was the allegation? Why there was a need for change of this agreement?
My lord. Your lordship,
My lord,
the agreement, my lord, page 14 and
Nath,
my lord.
you are prepared, clear with the facts. Because yesterday, the very young counsel, I mean, for a few months, my lord advised him that how to prepare, how to address. So when a specific question is asked, so straight away come to that. Or if you are not prepared, then you have to be
My lord,
candid to that
after, my
extent.
lord, after so that your
You
lordship
are
does
not fully prepared. You
My
are
lord.
not fully prepared. You have now got the point.
My lord.
Okay, there is a agreement operating.
Yes,
There is definitely a different bill pattern.
my lord.
So, and a bill pattern continues for a long time. So consumer comes forward saying, what is the meaning of holding on this agreement?
My lord.
So you bring an agreement in terms of the bill pattern, and consequently all other reliefs have to be granted. Maybe GRF has considered that to be genuine and allowed. So therefore, pinpoint argument.
if only if your lordship
Yes.
only if your lordship permits, may
No,
I pray-
after he completes, Mr. Nath completes.
Better, you wait.
my lord,
My lord, I pray after application so that I
Command saja ke rakho
my lord,
to be utilized as and when required.
my lord.
Mr. Nath, here is a case where your meter testing report shows there was no consumption of electricity.
Yes, my lord, but here is a case, my lord, that is a ST line.
So, I'm not asking you, page
Factual
38,
aspect,
factual aspect.
technical expert.
I'm not
opinion.
asking you whether HT or LT. Kindly take page 38 of your brief.
Yes, my lord.
Para 6, they say that we went on paying bills.
Yes. To the,
Then read 8, 9 and 10.
to the utter surprise of the complainant,
Upon
without,
receipt of the said letter.
yes. The-
8, upon receipt of the said letter, respondent remained silent and did not address the grievance of the complainant for which the representatives of the complainant, read.
With, my lord, to the utter surprise of the complainant, without supplying the electricity power as per agreement, the opposite
It match karuni sir, apna bodhe, you are on some other page.
page 30.
Page 38, paragraph 8.
8, sorry, my lord, I have in the beginning 6, my lord, I have read in 6. 8, my lord. Upon the receipt of said letter, the respondent remained silent and did not address the grievance of the complainant, for which the respondent of the complaint verbally requested to opposite party and visited their office on several occasions but failed. Finding no other alternative, the complainant thought that the authorized representation sent another representation dated 13/7/2020 detailing the grievance and requesting for immediate action, madam.
Sir, don't stop, read further.
Then
My lord.
next,
Pursuant- my lord.
very important.
Pursuant to thereto, the dated 15/7/2020, the opposite party officially visited the premise of the complaint for the field meter testing and furnished their report on the said date. Then, para 10. While the meter reading on dated 3/12/2016 shows the 2023.4 kV watt, the latest meter reading dated 15/7/2020, it is almost after 4 years, shows that 24.9 kV
So
watt.
there is no
Such-
power supply. There is consequently meter is not running.
Yes, ma'am. Such reports
So
shows.
these are factual findings.
Yes, madam.
We have already rendered so many decisions on
Yes.
this line. Factual findings by experts, visiting the spot, visiting the meter, giving a report. How do you improve your case? Why are you pursuing these litigations?
Like they want, let's see, remand the matter so that I.
No, there's no possibility of remand. Then we will be discarding the technical expert report. You send your officials for a report on spot. You got a report, but you are working contrary. Your billing here, your performance here remaining contrary to your own people report. Can you work? I didn't part from. Case is already dead by virtue of our judgments.
Yes,
We only give you some liberty. Just go through those judgments and simply say that it is already covered by so and so.
yes, sir.
Nothing else. Because as my learned brother shown you, those 4 paragraphs can only be taken down and the case is to be closed. Nothing remains.
Unless some part of.
Vigilance को दे दो If there is no power supply, how you are functioning?
No, through this, my lord, power supply, only certain portions of that entire premise was found. There are other power supply in the entire premise.
So you say even with the closure of those premises, the establishment could have run.
No, my lord, in fact, this is one of the connections to the entire premise. This is the Odisha.
Mr. Marana, you must have got the question.
My lord.
Apana jodi, you didn't have electricity supply
Okay.
or it is not consumed.
My lord.
But still you went on paying.
My
Your
lord.
answer is that since it is a big premises, there are multiple connections.
My lord.
We are running.
My lord. This particular connection was only taken.
But you
for-
went on paying the money. Are you so benevolent? by nature.
In
I
fact,
mean, that organization is very well,
Wait,
looks to be
wait,
very
wait,
benevolent.
in
You
fact,
went on paying for 2 years also.
only demand charges were raised because of that regulation.
Contract demand, minimum demand charges.
Minimum demand charges.
Sure.
Because your lordship had held that regulation 16 and
Why, if there is no power, so when the minimum demand comes to exist?
after my lord, 2 months if we do not.
Supply ଥିଲେ ତ supply ଥିଲା ଗୋଟେ vigilance କୁ ଦବା.
I'll take it straight.
All right, after vacation, the part in part. Okay, first two. Mr. Rao, you are not there?
Yes, I'm sorry.
We
but
thought you, there's no
I was
interest.
waiting here and just I was called and
Huh?
I was here, but then by the time I was called in other court and missed
Okay,
it.
ତାହେଲେ after vacation ରଖିଦିଅ. Item କେତେ ସେଟା?
8.
Item 8 after vacation ରଖିଦିଅ. See, the maybe there will be amendment in the cost title.
I have already filed a petition that was
You have already
allowed.
filed.
That was allowed.
ଆସୁ ସେତେବେଳେ ଦେଖିବା ସେଟା କଣ 17607?
But I
There are two applications. One is 22, one is 23 year.
4123 4107.
ଆସୁ ଦେଖିବା after vacation ଆସୁ ଦେଖିବା. Simple adjourn କରିଦେବା after vacation. Interim order was there.
That's till disposal of the
Continue. All right.
Item 10,
Item 10, your lordship may put it to after vacation.
और तो पीछे होने दे और कहीं टेक अप करना चार बाबा की दिखा हुआ adjourn करके उठी बोल matter other than electricity issue 10th electricity issue
मिलो.
कौन कले आपण comply करछंती
नहीं इटा ombudsman order को हमें challenge करिछु. I pray after vacation lords. I could
after
not put.
vacation or on the request of learned counsel for prisoner after vacation any interim order
Yes.
operating
Yes.
all right এটা ombudsman order challenge
Yes.
करछंती ombudsman रे तो compliance order ହେଇଥିବ
नहीं, against the GRF order, the OP2 moved to the ombudsman.
Acha, okay it's adjudication
No.
not execution
Not-
reverse
କଣ retail କି tariff ନା କଣ RST ର full form କଣ?
Retail supply tariff.
Supply tariff. ସେ tariff order call for ହେଇଥିଲା ତାର impact କଣ?
Tariff order ରେ ସେଠି provision ଥିଲା ଯେ ଯୋଉମାନେ less than 70 kV ରହିବେ
ଏଟା ତ ଆଗରୁ ବି ଥିଲା
ତାଙ୍କର LT tariff ରେ billing ହବ.
correct ସେଟା ତ ଆମର କେତେଟା decision
Yes, GRF also held so. The
Again?
GRF also held so. The ombudsman held contrary.
ନାଇଁ ଆରେ health show କହିଲେ କଣ ବୁଝାଯିବ ସାର୍
ହେଲା।
70 ରୁ ଅଧିକା ନା 70 ରୁ କମ ବୋଲି କହିଲେ GRF ସେଟା state କହିବେ ନା
ନା,
କମ ଥାଇକି LT କହିଲେ
ନା ଅଧିକା ଥାଇକି LT
No,
କହିଲେ
GRF hold his contract demand is 55 kilowatt.
ତାହେଲେ 70 ରୁ କମ
so less
70
than
କମ.
70
And GRF hold that
consequently LT charge
LT tariff. The ombudsman held contrary. That
ombudsman
ନାଇଁ,
what
ଆପଣ ରିଡିଂ କୋଉଥିରେ ନେଲେ LT meter ନା ST meter
no, HT, there is a HT meter and LT meter.
both ଆପଣ କୋଉଟା ସାର୍ ବିଲ୍ କରୁଥିଲେ
HT.
ସେଟା ବି
HT meter.
ST ରେ ବିଲ୍ କରୁଥିଲେ ତାରିଫ କଣ ପକଉଥିଲେ
LT. Because of less than
ଗଲା
70.
ତାହେଲେ ଆଉ ସେଥିପାଇଁ ସେ ଜୋରରେ ସେ ନୋଟ କଲେଣି ସେଥିପାଇଁ
Because of less than his contract demand less than 70 kVA, LT tariff as per the
ଆପଣ
RST.
କେତେ ଜାଗାରେ ଏଇ ଜିନିଷଟା କରୁଛନ୍ତି HT ମିଟର ରେ ରିଡିଂ ନେଇକି ତାରିଫ ପକଉଛନ୍ତି LT
No, it have because
no ଆମେ କଣ ଏଟା ଜାଣିପାରୁଛୁ ଆମେ କଣ ସେ because this is the pleadings in cases
yes.
and there is a factual finding in that regard
Yes. I have
LT
also
ତାରିଫ କାଇଁ ନଉଥିଲେ
no, that is the
କଣ 5 ଟଙ୍କା 35 ପଇସା କାଇଁ ନେଲେନି 7 ଟଙ୍କା 10 ରେ କାଇଁ ନେଲେ
no, because of his contract demand less than 70 kVA, the RST order provides to take LT.
sir if ଆପଣ ତ ମିଟର କହୁଛନ୍ତି HT ରିଡିଂ ନେଇଛନ୍ତି
HT is a HT connection.
ଏମିତି ବି ନୁହଁ ଯେ ଆମେ କିଛି ବୁଝିପାରୁନୁ
ସେଥିରେ
ଆମେ ଯେତେବେଳେ ଆପଣ ଭାବିବେ ଇଏ କିଛି ବୁଝିପାରୁନା
ST is a ST connection. ST connection.
ST connection
Connection
but
reading ବି ଆପଣ HT ନେଇଛନ୍ତି
LT
metering
HT
ତାହେଲେ condition attached to LT metering will be applied everywhere
HT agreement, HT meter, HT records billing at LT.
Because of the arrest provision.
That is the sole point.
And because of the arrest,
Again.
example can I specific deal
after vacation.
Item 12,
Item 12, this order of the ombudsman is under challenge. Order of ombudsman is under challenge, and OP1 was to file counter. Twice they have taken
What
time.
counter here?
Counter is also not required.
No,
He
not
insisted
at all.
not required also. A date may be fixed after vacation for final hearing.
Okay, counsel for petitioner wants adjournment. I'll place this matter at first week, 22 ଅଛି ନା?
ଆଜ୍ଞା।
Third week July. Third week July.
But
Interim order operating.
interim order is there. We have to follow the order of the ombudsman. So that will be subject to the result of this.
Now it's elected. So that's a final order, the
Final.
interim final.
Well,
Correct.
may I please your lordship, my lord.
Yes.
The last order was passed on, my lord, 2019. Still, till that date, my ROR has not been corrected, my lord. Several orders since passed by this honorable court in writ applies the result content meets on, my lord.
What was the last direction?
Last direction, my annexure
Annexure
5.
5, yes, please read para 7.
Yes, my lord. In that view of the matter, the writ petition is disposed of with a direction that in the event the petitioner files an application along with the certified copy of this order to correct the ROR in his name, the Tahsildar Chandbali shall do well to examine.
All right. Then what happened?
I
This was
filed
passed in
annexure 6, my lord.
2019.
I filed annexure 6, my lord.
Yes. There's no improvement.
No, my lord. Thereafter, I also legal notice sent, but no remedy, my lord. Annexure 7.
Yes, this is unnecessary pending of, no, annexure 6, Mr. Mishra.
Yes, sir.
Annexure 6 cannot be pursuant to annexure 5. See, annexure the 6, the date, year of the case.
Sorry, man.
See the year of the case, it annexure 6. You said annexure 6 is filed pursuant to annexure 5.
Yes, my lord.
So,
But it was little late because no time limit is there.
just go to that page 34.
Yes, my lord.
What is that year of the case?
I filed this, my lord, in 22, my lord.
You have indicated 12.
12 is the mutation case number, my lord.
That's right, mutation case. You were directed to bring a mutation case in the earlier disposal.
Yes.
You said you filed this after the writ petition is disposed. No, this can't negotiate. Or there is something wrong here. You filed in 22 and you have nominated it as 12.
Because annexure 5 रे no limitation, no
Otherwise-
time period was not there, my
otherwise
lord.
is Mr. Panda.
बूढ़ा लोग
Otherwise, there is no possibility of mentioning 19 order.
My lord.
So why are you keeping such matters pending for such? I'll take it. Writ petition had the submission of respective councils. It appears the petitioner here there is a second round of litigation. and alleging the attempt and endeavor of the petitioner pursuant to direction of this court in the disposal of WPC so and so, order dated so and so, Annex 5. Okay. There is no improvement shown on the request of the petitioner. Annex 6 is a disclosure of petitioners further moving to the competent authority in the year 22. Okay, this court finds strange in the attitude of the Tahsildar OP number Chandwali.
Yes, OP number 3, my lord.
Hello. And in disposal of writ application, direct the Tahsildar Chandwali. Okay, now you tell what is the actual case number, mutation case number kete?
Mutation case number 1919 of 2012, my lord.
1919 of
2012.
12, but dependent on subsequent information.
It is in 23, my lord, page 23.
Through the development in the aforesaid writ application, at least by completing such exercise within a period of 3 months, failure of which it shall be construed to be deliberate violation of direction of this court and inviting a suo motu contempt. Yes, next case.
Annex 4, my representation pending, my lord. This was in respect of lease of a village pond, my lord. Though we are the higher bidder, but in our
What
behind.
is the position, whether the lease has been executed?
Yes, my lord.
If lease executed, then what is the subject here?
But immediately we put our grievance before the
So
by Annex 4, my lord.
Then you can't bring any attachment to the auction. It should be treated as a further request. এই ପୋଖରୀକୁ ଆମେ ଅଧିକା ଟଙ୍କା ଦେଇ ନିଲାମ ନେବାକୁ ସତ ଅଛୁ। ବର୍ତ୍ତମାନ କଣ କରାଯିବ? 24(9) representation, can it be considered now? What is the position in auction?
Auction already.
Then all right, at the submission of Sri Misra, who understood. Makes a.
Let me man Annex 4 be taken. Annex 4 may be taken into consideration.
Sorry, Bhavani. You may bring a fresh application on a fresh cause of action, but on that you can't bring. On his own submission, Annex 3 is already worked out. And there is undisputedly execution of lease in the meantime. In this circumstance, this court finds there is no strength in undertaking the exercise through Annex 4. The petition declined to be entertained. It is only observed, it is however observed in the event petitioner has any fresh cause of action, may revive his request by filing appropriate representation. Please, next.
Item 3, item 3, correction of the error where the legal heirs of the deceased.
Any mutation case pending?
Yes, my lord.
What is that case number?
Sorry, my lord.
Mutation case number.
Representation pending, but it's not in the record, my lord.
Then why are you filing these requisitions?
So बुढ़ा लोग हैं हज दे but fresh file fresh.
No, you don't even disclose case number if any pending. How can High Court direct Tahsildar to undertake such exercise even? Withdraw karandu. There is no disclosure on the pending of any mutation application if any. The requisition cannot be entertainable in this scenario. Petitioner being permitted to withdraw the writ application, also permitted to bring the proper writ application.
I'll file and fresh representation.
Yes.
Obliged.
And only after making his endeavor before the competent authority. Yes.
Item 4. Obliged.
Item 4, your lordship. Last opinion, state was there.
Instruction
After requisition. The matter has been adjourned twice. State Council submits, there is no instruction as of now.
Your lordship, maybe date may be given. A date may be given, your lordship.
You know, I am sitting in this assignment after vacation. Why are you interested for a date? Suppose some other judge sits, he may not go by these dates. No, second week June. Second week June, after vacation.
Lordship. Item 5, deeply obliged.
Yes, fine.
I may kindly
But
be
as a matter of
permitted,
last chance.
my lord, I may kindly be permitted to
Ensure
place the
receiving
matter.
instruction by next time.
My lord.
Ensure receiving instruction by next time.
Yes, yes,
1 month already over.
yes, my lord.
Yes, madam.
I may kindly be permitted to place the matter
For
on
the
behalf of
disposal of appeal.
applicant counsel.
Mutation appeal,
Is
pleading
pending
completed.
and by annexure 2, my lord.
Mutation appeal is pleading completed.
Yes, my lord.
You are sure notice has been issued in mutation appeal?
Yes, ma'am.
All
But
right.
till date not
Filed on
finalized.
5/1.
Till date pending the
5th January file is.
That's right. That's why I am asking. She says notice is already complete. Okay, in the event notice is already complete, then you undertake the says. Counsel appearing for the petitioner makes it clear that there is already service of notice on the respondent in mutation appeal 5 of 23. This court, however, finds the appeal was brought hardly on 5/1/23. Be that as it may, in the disposal writ application, this court observed in the event pleading in mutation appeal 5 of 23 stood completed. A lawful disposal to such appeal be given at least within a period of 3 months from the date of communication of order, but in the involvement of the party likely to be affected.
obliged.
Item 6,
Item 6, my lord, your lordship's direction, that Tahsildar Jatani is present. And I have
What was the direction?
to correct the
8
record of
years,
right.
8 years have passed.
Yes, we have
What is the
already,
reason?
already corrected. me.
In between?
Yes.
In between. But why, madam, why it took so much time?
ସେ
Who is the Tahsildar?
ଏମାନଙ୍କ knowledge ନଥିଲା ସେମାନେ 2006 ସେ ସେମିତି ରହିଛି ଆଙ୍କ knowledge କୁ ଆଣିନାହାନ୍ତି.
Are you shielding them?
No,
Why a mutation case should be pending for 10 years?
that's why my lord, I have already instructed them.
So I may let you off. But hereafter, if I find second offense, these are clearly offense by public officer. Yes, in the course of submission, got a copy them they
ଦେଇ ଦଉ ସେ xerox କରି ଦେଇ ଦଉ.
in the course, okay, pursuant to direction dated 9/5/2023, there is appearance of the Tahsildar, namely,
ଦେଇ ଦଉଛି ଲେଖିକି ଦେଇ ଦଉ.
ଲେଖିକି ଦିଅନ୍ତୁ ହେଲା Tahsildar Jatni?
ଜଟଣୀ.
Jatni, এটা correction of
ତହସିଲଦାର and additional ତହସିଲଦାର both.
ভুল হয়ে যাইছি এটা করে তো Jatni, who in personal appearance submits there is already finality to the miscase 99 of 2019
13.
by bringing the corrected record of right.
Yes.
Sri Panda also attempted to produce the corrected record of right. This court observed a copy of corrected record of right be handed over to the petitioner. For there is substantial development and by completion of the mutation proceeding in the meantime, this court disposes the writ petition accordingly, and there is no further necessity of attendance of the Tahsildar so and so.
That is 99/13. 99/13 case number. Your lordship writing 19 आएगा.
Case number
99/13 up 2013.
99/2013.
That is lease miss case. Yes.
Well, our order kon bhul hi jaychi. 99 of 2013. Yes, absolutely. That's right. All right, ask them to go.
Yes.
Item 7,
May it please all my lords. My lords, item 7 and 8 are issues are same, my lords. I'll be much obliged, my lords, if your lordship may take up item 8, that is WPC 139 of 13935 of 2023.
All right, all right.
My lords, I'll be much obliged, subject to your lordship's convenience. My lords, what has happened here, my lords? in Kapileshwar village in Bhubaneswar, phase 1 and phase 2, there was a buildable area of 5 acres of some land.
Yes.
But the Orissa State Housing Board could not build up the houses, and it wrote a letter to the GA department. Lordship will kindly see Annexure 6/1 at page 35, madams.
Yes.
For sanction of the area.
Additional area.
Yes.
Hmm.
To the Director Estate and Additional Secretary to Government GA Department, madams, for handing over this area.
Okay, it appears thereafter there is some
Mallards.
thereafter
Then
there
there
is some
was an
development.
advertisement by the
They
State
went
Housing
for
Board.
advertisement.
Yes, advertisement was made, Lordship will see, by the Housing Board.
Annexure 8.
Yes, Annexure 8, mallards.
Hmm.
And page 39, mallards. Pursuant to which I made a application.
Annexure 9.
9 at page 40.
It is still pending.
Still pending, and Lordship will kindly see Annexure 10 at page 41 and my willingness. They asked me to appear in person. I have given in my willingness by the Annexure 11, page 42. Nothing happened, mallards. Only 760 a piece of this strip of land is there, mallards. Only
All
for
right, all right. Let them take a decision
yes,
on that. It's a pending case. Let them take a decision on that.
mallards.
I had the submission of Sri Roy Senior Counsel.
May I pray, mallards, only a time limit if your lordship may
Yes,
kind.
yes, definitely. I don't
Mal-
pass any order without stipulation of time,
With a personal hearing, mallards.
if necessary.
Mallards.
All right. Background hearing. Finding a strip of land lying vacant, petitioner approached the Odisha State Housing Board for allotment of such land in his favor. Appearing by Annexure 6, na? Repentation Annexure 6.
No, mallards. Repentation is Annexure 9, mallards. Page
No,
40.
presently, earlier.
Earlier, mallards, Annexure 6 is the outline, layout plan of the Odisha State Housing Board
Okay,
at
all right,
page
all right,
34.
all right. In the meantime, considering the issue on sanction of additional build-up area within the Kapila Prasad, the housing scheme, Odisha State Housing Board, there has been some decision for issuing an advertisement for the purpose and inviting applications from interested parties. As appearing at Annexure 8, advertisement has already been issued with the aforesaid intention. In Annexure 9, petitioner appears to have made an application requesting for allotment of area mentioned therein by submitting such application on 11/10/2010. Through Annexure 10, it has been established petitioner was communicated by the Odisha State Housing Board for remaining present before the authority issuing such letter on the date and time fixed, and also for submitting his willingness in the allotment of the land measuring 780 square feet adjacent to the house of the petitioner, number 51/A, private plot, bracketed, at Kapila Prasad, phase 2. Annexure 11 discloses petitioner in the meantime has also, immediately thereafter, has also submitted his or her consent. Okay, through the writ application, allegation is made. There has been no further development. Pursuant to the calling for application from interested person unnecessary, and even after taking the dispute to the proceeding to the stage of calling for consent of the party, and even after the party submitting its consent by unnecessary 11, considering there is inordinate delay, this court in the disposal of the writ application observed in the event the issue involving advertisement unnecessary and the request of the petitioner unnecessary 9 shown development through unnecessary 10 and 11 has not been concluded. Decision as appropriate, keeping in view the development through unnecessary 10 and 11, the shown at least within a period of 3 months from the date of communication of order. Mr. Roy, you are assisted by your Mr.
KK Sahu.
Mr.
Kirot Kumar Sahu.
Kirot Kumar Sahu. Right. Then what is the issue in the other case?
But the same.
Some only annex.
Only annexer 10 is my representation dated at 21.
All right.
Sorry.
This court in the earlier
Annexure
hearing of
10 page 51.
WPC number so and so has already dealt with the issue involved herein. Direction therein shall also follow here. However, keeping in view the advertisement unnecessary 8,
Yes.
request of the petitioner unnecessary 9, and there is no calling for consent here.
No matter.
Then what is unnecessary 10 a
10
subsequent
is minus,
representation?
I have given my.
No, here there is no calling for consent or.
No calling for consent, madam.
Okay,
can we
tell
take
khali
for
8 and
allotment?
9. And the subsequent representation of the petitioner at unnecessary 10 hearing
Madam.
by working it out within 3 months.
Madam.
Yes.
Obliged, madam.
Item 9.
Much obliged.
Yes.
May I please alert? Here the revision petition has been dismissed.
Mr. Ratha, why are you not filing type copies of these order sheets?
Yes.
Unnecessary 3 you have filed,
I have-
nothing readable.
I have, your lordship may kindly see page 6. I have quoted the impugned order, last order. Page 6.
You challenge unnecessary 3?
Annexure 3, order dated 14/1/2019.
Yes, please read that portion.
In spite of repeated calls, none appeared. Petitioner's counsel filing a time petition on 22/10/2016 never prosecuted the case since then. The petitioner document cited in the document number 2166 of 1974 has not been corroborated in the plaint. Further, the
So this
document.
is an expedited order.
Yes, my lord.
Similar matters were there yesterday or day before yesterday.
No,
Similar matters were there.
No.
It is what proceeding? What is the
It is
nature of
the
proceeding?
15B of Odisha Survey and Settlement Act for correction of
15B.
record of right.
Okay, yes, Mr. On the private parties are there.
One private party is there.
One private party. only you have to
Two,
take
5 and
notice.
6.
Issue notice. Then who is 5 and 6? Two private parties are there.
My lord, 5 and 6.
All right, issue notice on the question of admission. Fixing short returnable date, case be listed immediately after service of notice on OP number 5 and 6. ऊपर लिखो impugned order is assailed. Impugned order at annexure 3 is assailed on sole ground of being decided in absence of the petitioner. This court is inclined to issue notice. Right.
Item 10.
BPB charge undertaken by tomorrow.
May I please, Lordship?
Yeah.
Lordship, item 10, the prayer of the petitioner is for direction to OP number 1 for renewal of his passport. Lordship, in person,
renewal of
order
passport,
dated
Lordship, keep
5/5
it some other day because no document is issued except the last annexure. So we have received the copy on 4/5. We sought for instruction some other day. It is a renewal matter.
Taken up on 5/5/23. So you are directed to take instruction
Lordship.
whether any further development.
Lordship, he has applied afresh.
Okay.
Lordship, I just pray for, that your Lordship may kindly consider in light of your Lordship's order dated. I'm sorry.
If you have applied phrase, then that has to be given a logical end.
Lordship.
And
Lordship may dispose it of
And the
in light of
decision,
this.
and the decision may be
Lordship.
taken into
My-
consideration.
My case is fairly covered by a Lordship's order.
No, my lord, Lordship may see the page 32, page 32.
No, now he says there is a fresh cause of action. So he
No, my
does.
lord, he has asked to appear before the authority. There is a last paragraph, page 32. The ministry has communicated the same. The regional passport officer wrote a letter to him.
Mr. Padhi, that is no more enforceable. He has applied a fresh application.
Yes.
So therefore, he doesn't want to press the writ application. His fresh application is pending, be given a logical end.
Sorry, madam. I thought that is earlier.
No, he's not pursuing this.
Yes, yes, sir.
And
Sri Patnaik, sir.
Sri Patnaik makes it clear. Okay, pursuant to direction dated 5/5/23, Sri Patnaik makes it clear that in the meantime, the petitioner has a fresh application for grant of a fresh passport, pending consideration of the authority. Okay, this could also involve and therefore submits nothing is there to be advocated in the present writ application, except giving some observation inter alia direction to the regional passport officer in giving a lawful disposal to the fresh application at the instance of the petitioner pending at this moment. Okay, finding reasonable prayer in the disposal of the writ application and after involving the submission of Sri Padhi with କାହା ସାଙ୍ଗରେ ବସିଛନ୍ତି? ପାଢୀ ବାବୁ କାହା ସାଙ୍ଗରେ ବସିଛନ୍ତି ଆପଣ?
That a family
Amita Pradhan.
which is in
Amita
need of such
Pradhan.
rations
Amita Pradhan.
and whose children
Lordship may
Dispose the writ application directing the regional passport officer to give a lawful disposal to the fresh application.
Lordship, if
passed
any
by the-
affidavit, as regard to my criminal cases, if an affidavit is to be filed, if any affidavit,
Okay. That you comply the necessary formalities.
Lordship
there.
may kindly.
Okay. Following the observation through the judgment of this court, WPC 4834 of 22, it may be open to the petitioner to bring affidavit
Lordship.
in the disclosure on the status of criminal cases, if any, on the date of appearance before the regional passport authority, and the regional passport authority thus directed to give a lawful disposal to such application while also keeping in view the observation and directions of this court in WPC 4834 of 22. By working it out at least within a period of 1.5 months from the date of communication of order, with clear intimation to the petitioner for his appearance and giving clarification on any doubt, if any.
Much obliged.
Item 11.
Yes, 11.
I may please my lord, the revision petition is pending for admission.
Admission,
Fresh admission,
fresh admission.
my lord.
Okay, all right.
11 and 12 are
They're
same.
all
Same identical.
same item 11, 12 and 13.
Yes, ma'am.
Okay. ये बदले देले आउ कि आसिले परत न आउ डका is 13 on the side.
Item 14.
14.
Item 14.
Mr. Ghosh, any mutation application pending?
My lord.
आज रिजेक्ट करवाटा नॉन अपियस ठीक होने
ना
म्यूटेशन तो अलाउ ही चिठी पेज 11. So you are not publishing the record of right in terms of page 11.
Record keeper actually has to.
So all right, if this order is not varied in the meantime, you give
Then-
bring
order
out
has to
a
be-
fresh record of right. None appears for the petitioner, however. Perusal of brief and involvement of the submission of Sri Ghosh, then at AGA this court find. Through annexure 11, there is already direction for correction of record of right. This court accordingly, in disposal of the writ application observed, in the event there is no change to the legal position by Dhaneswar page and Dhaneswar 2, page 9 to 12. There should be bringing out of a corrected record of right by working it out at least within a period of 1 month from the date of communication of order. Free copy to State Council.
Item 15.
My lord, on behalf of Biswanath Rath, my lord, kindly pass over.
Pass
Please,
over
Lord.
after vacation.
Please,
Or tomorrow before any other bench kar daba. Mu asuri kalli.
Yes, instructor will take.
Kalli
time.
asu. No, I'll be rising early. That's why I'm sitting early. Tomorrow before any available bench. Yes.
Item 16.
May I please, my lord?
Yes.
My lord, my annexure 5 is pending before OP number 1. Though demarcation case has been initiated.
No, Mr. Counsel, demarcation proceeding, I don't appreciate these representations. Go file in proper format.
Lordship, may kindly peruse annexure 4, page 21, your lordship.
Proceeding is already there.
Yes, your lordship, notice were issued.
Then what is your request by Dhaneswar 5?
Annexure 5, the notices were issued, date has been fixed for demarcation. But demarcation has not been done.
Then it is the responsibility of the Tahsildar. Why should High Court direct?
I have filed a representation before the
No
collector.
representation necessary. Dependent on contingency, this local situation, he will give a direction to the ISC. Not that High Court will issue a writ of mandamus here.
Lordship, I have taken several steps and tried to ventilate my grievance, but
Had the submission of learned counsel for the petitioner, she goes learned AGA. Petitioner has a serious allegation that in spite of several notices and attempt for demarcation by the Tahsildar Danagadi involving demarcation case number 33 by 2018, and 5 years have passed, the demarcation could not be conducted for local disturbances. Through Dhaneswar 5 and 6, petitioner brings to the notice of the court that there has been a request to the district administration for providing police protection for working out the demarcation exercise. For the opinion of this court, it is for the Tahsildar, if he finds to give such requisition. In the event he finds there is difficulty in working out the demarcation exercise, no representation of this nature can be considered by High Court straightway. Okay, it is therefore declining to entertain the request through Annexure 5 and 6. This court, however, observed in the event the Tahsildar, keeping in view that the demarcation case is pending since 2018, the Tahsildar Danagadi shall do well in asking for police requisition in the event there is in fact any difficulty in undertaking the demarcation exercise. By making such requisition at the earliest, there should be showing final outcome to the demarcation proceeding involved herein at least within a period of 3 months.
Obligation.
Yes, next.
Item 17.
May I please ask? My lord, the petitioner is a small scale unit. It's registered under the MSME Act. There is a preferential procurement policy by the units which is located inside the state as per the MSME Act. It's a guaranteed protection because otherwise they will perish. There can't be industrial growth. But this opposite party is dealing with, that is a very rare, this Indian Rare Earths Limited. They see sand in the beach, Gopalpur beach, Bali, it is within the protected area. So they have a dominant position to deal with the sand, and that is being used as a raw material in the petitioner's industrial unit. Industrial means is a small scale unit, 3-4 crores. So from year to year, after it was included in the Rare Earths Act, in 2016, this unit was set up and they have been providing also the raw materials. This
Now in between there has been stoppage.
Let's stop it. Kindly look at There was some
Where
allegation.
is that letter dated 2/1/23?
No, he came before your lordship earlier, that your lordship would find the order of this honorable court at page 84, my lord. Page your lordship directed that he had submitted a representation. My lord, let me just one more sentence.
Yes.
There was some allegation against one of the staff of my staff and one of the staff of the IRE. Police investigated into it and they submitted the final report exonerating him. That this allegation, they had some transaction, I don't know what is that, because it was between the staff or two staff of the, so it has nothing to do with the supply. So they stopped it because of the pendency. I came before lordship.
That
Your
was the
lordship-
reason.
Your lordship disposed it up on the direction that he has submitted a representation, let it be considered. Notwithstanding the submission of the final report, not stating that the allegation incident is false.
Situation is still conducive.
Still continuing, they are not supplying the material. Recently, they have been indicted by the Competition
Mr.
Commission.
Acharya, there is no point. We will be issuing notice.
My lord.
Because industry is likely to be perished.
So that's correct. So in the meantime,
Then what interim order possible now?
interim, let them go on supplying. I am purchasing, my lord. Not
No,
that
we
they-
can fix early date. No interim order is possible.
No,
Unless
otherwise,
we
my
set
lord,
aside,
there
unless
are,
we
my
set
lord,
aside.
around, my lord, 30, 40 employees, poor employees. I can pay
So
them.
we fix the
So
date
that
at
is-
the earliest after vacation.
So vacation, I know, my lord, but any sort of without prejudice, let them supply
No,
the
sir.
material.
So it's-
So my lord, there is nothing
There is
supply
no
of, my lord,
supply,
I will
Mr.
purchase.
Acharya, there is no supply at this moment. There is a negative order.
So there is
therefore-
no order. You lordship
No,
can
you-
look at that order.
Come
Why
to
are they?
prayer number 2.
Prayer number 2.
You want to setting aside that communication.
That order communication. My lord, you lordship can kindly look at that order. What they state. They
Annexure.
say that because we are proposing to file a annexure, my lord, impugned order, your lordship would find it. Annexure.
Prayer did not disclose the annexure.
Page, my lord, 95. Page 95, I'm sorry. Page 95.
This 2/1/23 letter.
No, my lord, 2/1/23, yes.
Page 90.
96, my lord, your lordship would
96,
find.
yes.
This has reference to your letter dated once was received by us.
So
on-
that is annexure
after
14
the disposal.
series.
Yes. The annexure, my lord, 14 series.
14
Your-
series,
yes,
page
at
96.
Page 96. My lord, your lordship may kindly look at the reasoning. That is very funny, my lord. So this has reference to your letter dated 2/9/22 as received by us on 7/9/22, forwarding the order of the Honorable High Court of Orissa dated 26/8/2022, passed in WPC number so and so. Having gone through the order of the Honorable Court, the attached writ petition and the documents annexed thereto, we came to learn about the closure of GR case.
say-
My lord, they admit that the case has been closed. As in such respect, we have taken up the matter before the Honorable STJM Chhatrapur by filing a complaint case, my lord. Because a complaint case has been filed, my lord, they can take
So
recourse
that's
to
why,
this
that's why
drastic
you may
action and
have a
stop.
point, Mr. Acharya, you may have a point to make
Yes.
out, but no interim order possible at this stage.
My lord, interim
Take out
order,
notice
what
in
I'm
both,
praying.
take out notice in both. Had issue notice. on
By
the question
special
of-
messenger, your lordship may permit, otherwise, my lord, I can't
Pardon?
run the, by special messenger, your lordship may permit, otherwise I can't run this unit, my lord. 30 employees have not been paid
But
for
this
the
is-
last 3 months.
Mr. Acharya, what is the hurry? This communication was made in 2/1/23. And you are in May middle.
No, my lord, they were
So 4 months
negotiating.
you waited, can you not wait for
My
another?
lord, I can wait. They negotiated. They assured that no, we'll resume supply. I waited because your lordship knows it is difficult because they are the only supplier.
All right, I give you liberty in the
Yes.
vacation.
Your lordship may direct that, or I can take notice by special messenger.
Special
So that
messenger, if
any
you
date,
take-
reopening date, your lordship can fix. Reopening date.
All right. Had the submission of the Acharya and the senior counsel assisted by
Mr. A.B. Patnaik.
A.B. Patnaik, Mr. A.B. Patnaik, okay. This case has a checkered history.
Not even if a case has been filed, it doesn't
In just one-
disentitle me to purchase.
In
They
the
are the
earlier
only
occasion.
millard seller.
In the earlier occasion, WPC 20712 of 22 was heard and disposed of, directing OP1 to consider the repentation of the petitioner. by disposing the writ petition on 26/8/22. It appears as a consequence, communication has been made to the petitioner by page 96 and part of annexure 14 series, disclosing that for declining to come to the rescue of the petitioner on the premises of pendency of a complaint case before the SDGM Chhatrapur, registered as complaint case 1CC 14 of 2022, claimed to be pending presently. See, Acharya taking to the pleading position submits the complaint involved in the aforesaid writ application was investigated, and in the meantime, police has already submitted final form and urges this court merely the operation of the industry involved should not be obstructed merely on the premises of pendency of a complaint case before the competent authority. This court find there is a case to be examined directly, accordingly direct issuing notice. Miscase notice one said, however, considering there is urgency for the petitioner establishment virtually closed long since, remaining inoperational for last so many months, this court permit the petitioner to take out notice by special messenger, and the matter may be placed for the purpose of interim order. Directly placing the matter. Yes, asilani ki list asilani. Vacation re ko kebe basuchandi. Kali ki asibo. Tale kon kore. In the second bench kar daba. First bench re possible habani. In this
second bench.
In the bench, in the single assigned bench.
Millard, I'm sorry. Single that time I may remain absent for 7-8 days. Millard, during the vacation, may be given liberty to move during the vacation.
Okay. Liberty like okay, considering urgency involved here in the matter, maybe the liberty granted to the petitioner to move the vacation bench after the service remain complete on the opposite parties.
Obliged. One prayer, may I, if your lordship would permit, the pendency will not disentitle me to renew my prayer, nor the authorities. Obliged.
Once you are getting into a writ petition,
my lord,
how further
let it come.
Nothing is pending now. After that letter is issued, they have closed your case.
They have, my lord, in fact, no, they
Virtually,
were negotiating. We are giving
their intention,
mischief.
their intention appears to be they are nothing. They are going to do nothing until the complaint is closed.
No, that's correct. No, but one thing, Millard, recently they have been strictured by the Competition Commission because they enjoy this whole, because that's the only body which Millard is having the right to sell it.
Anybody else is receiving?
My lord?
Anybody else is receiving, or it is totally?
No, they are selling it to others. They
so
have
there
a
is
setup.
benefit.
Yes, your lordship can now, I should not say more, your lordship can understand. They have their own internal arrangements to do business. So that's
a valuable property. Therefore,
yes, they know it's a question of disfavoring someone at the cost of favoring.
You take special messenger notice on
OP 1, 2 both, Millard. They are the same one. 1 and 2.
They belong to one place.
One place, Millard, Chhatrapur.
So two special messenger cost they were. Two special messenger cost.
The number one, it's in Mumbai.
So
yeah, that's
you
correct.
say you will be taking in.
No, I'm sorry, Millard. The number 2 is in Chhatrapur, Ganjam.
Then who will be
the
contesting?
chief manager. No, he is the local head. Number 2 is the local head. One I will take by speed post, my lord. Mumbai would be too
One
expensive.
speed
He
post
can't
kar
afford.
deo. 2, 3, 4 in one area.
No, 1, 2 only. Two opposite parties.
Two opposite parties.
Two only Indian
Okay,
Railways. It's a
one
public
by
sector.
speed post, 2 by special messenger.
2 by special.
Hala.
Blood.
Liberty after the service is complete.
Mumbai.
To move in vacation bench. On the interim aspect, yes.
Not 1 by speed post. 1 by speed.
Yes,
Obliged.
cost be assessed and intimated to petitioner by Monday.
By Monday. Obliged.
Item 18,
May please your lordship. 18 lordship, similar matter lordship issue notice. Kali भी गोटे थला. 15 भी order is challenge lordship.
15
notice.
I am not interfering.
କାଲି ଗୋଟେ ମିଷ୍ଟର ସିଆର ନନ୍ଦ ବୋଧେ କରୁଥିଲେ ସେଇ ମ୍ୟାଟର ଯୋଉ ଆପଣ ନୋଟିସ କରିଥିଲେ
କାଲି ଗୋଟେ ମୋର ବି ଗୋଟେ matter 31 item.
କଣ ହେଲା notice ହେଇଛି?
ହଁ ନୋଟିସ କରିଛନ୍ତି
All right, sir.
Obliged.
Yes, next.
item 19,
May please your lordship. Lord, annexure 4 and 5 issued by the municipality authority under section 91 and 92 of OD Act is under challenge.
So why at notice stage?
Milord, because they have got no jurisdiction to initiate any proceeding under the Odisha Development Authority Act. They are municipal corporation. They are guided under the Odisha Municipal Corporation Act.
That's right, but they have a role in the OD Act. It was multi-storied building.
No, সেটা সিনা প্ল্যান করিবে এইটা 91 92 is regarding a demolition. Under the Odisha Municipal Corporation Act, there is no such power.
No, there is no such firm, but the power has been given to the municipal corporation for high-rise building.
Regarding the planning and regulation, it is not neither a high-rise building. It is an old building. Your lordship may kindly see. Old building, my house. I am only making repairing. The initiated 91 and 92. My query before your lordship Millard, I have challenged that such power under section 91 and 92 has never been conferred.
There is delegation of power. I don't
Delegation has not been done in spite of your lordship's direction in 2015 to LR Millard, Vijay Krishna, that hotelier, Puri hotelier case Millard. As yet, there is no legislation endowing the power under the statute.
respect of the building.
Legislation करने की चीज.
Requisition has undertaken by tomorrow.
Millard. Obliged.
Yes.
item 20,
May I please your lordship. Similar matters your lordship has already disposed of. Your lordship can found annexure 2. The order passed by the Sonora Court. Again.
item 21,
Yes, 21.
Revision.
Pardon?
Revision petition is rejected.
Similar petition has been rejected. Kete item thila kali?
Kali 17. 15.
Huh?
Item kali 15 thila.
15 thila same order of.
item 22,
demarcation pending for तहसीलदार अवस्था से नंबर को
Mic raise करंतु, nothing is audible.
आगे
It is for disposal of the demarcation case.
आगे सेरा नंबर करना कि प्रोसीड को
Number भी करना है.
आगे 5-4 फाइल
Through
annexure to अन्य page 11 में
Through annexure 2, it has been brought to the notice of the court that even though a demarcation proceeding is made on since 5/4/23, the Tahsildar Basta is neither registering the same nor showing any lawful disposal. at outcome. Okay, considering some post allegation, this disposes the writ application directing the Tahsildar Basta OP number
OP number 3, my lord.
lawful disposal to application if any pending by annexure 2. Also in the involvement of the boundary tenants by completing such exercise within 3 months.
Item 23.
May I
Yes,
please, your lordship?
23.
My lord, very limited prayer, my lord. My representation is pending before OP number 3, my lord.
Representation for
Annexure 4 series, my lord.
representation for
To change the, I have applied for the conversion of the my land, my lord, but that has been rejected. And in view of the report submitted by the JRIT, Jharsuguda Improvement Trust, my lord, reflecting therein my land is coming under plantation zone. But that was the my lordship.
so therefore JRIT has to take a decision.
My lord, my representation is pending. Similar order, your lordship has been.
But this appears to be a forest land.
Forest land, my lord, the annexure 4(3), my lord, clearly the director urban and housing and urban development department stated that he wrote a letter to the JRIT to change the nature.
Annexure 4 will be treated as an appeal.
My lord, annexure 4 series may be treated as it is appeal pending.
Para 2 prayer court kariyo, para 2 re rocking on.
OP number 3 has to take a
Annexure
decision.
4 has been is in form of an appeal pending before OP
3, my lord.
3.
My lord.
OP 3. Okay, considering this to be a pending case before OP 3, in the disposal of the writ application, OP 3 is directed to find a lawful disposal to the appeal of the petitioner by annexure 4. Further, also providing opportunity of hearing by completing such exercise within a period of 3 months from the date of communication of this order. While also 80 annexure 4 ta kon achi ki?
Annexure 4 annexure annexure 4 jota thila eta annexure 3 achi.
3. While
My
also
lord.
keeping in view the development.
The letter some
Annexure 3 herein.
My lord.
All right.
Certain observation given by the director to consider regarding the
All right. That's all. Yes.
Item 24.
obligement.
The petitioner taken the shop-run lease basis from the Gram Panchayat. The 10 years lease, annexure 1 the agreement. Page 17, the Sarpanch issued a notice to the petitioner that was received on 1/5/2023, giving 7 days time to deposit area amount and renew the lease. The petition received on 1/5, file a representation. On 6/5, another notice issued page 20, the lease cancelled by order of BDO dated 29/4.
Have they allotted that to anybody else in the?
My lord, page 20, the cancellation notice.
Cancellation, but have they allotted?
Yes, my lord, agreement annexure 1. No, diya hi nahi hoga.
It allotted to anybody else. So notice.
We will deposit the entire area.
So notice on the question of admission, fixing short return of the requisition as undertaken by tomorrow. In this case, notice as above, one set. As an interim, this could direct the shop room cancelled by communication annexure 6. Communication dated 6/5/23 by annexure 6 may not be allotted to anybody else without leave of the court.
Lordship, 26, 27, 28, 29.
Samastangara cancel is.
Yes, my lord. 26 to 29, same, my lord.
Your lordship has issued notice and stay.
Yes.
So Panchayat contest.
No allotment of the shop room involved without leave of the court.
Lordship, my notice is registered post, Lordship.
So 26, 27,
28 and 29.
28 and 29. All the last time. ସମୁଦାୟ କେତେଟା ଦୋକାନ ରୁମ୍?
My lord.
ସମୁଦାୟ ଦୋକାନ ରୁମ୍ କେତୋଟି?
My lord.
ସମୁଦାୟ ଦୋକାନ ରୁମ୍ କେତୋଟି?
14ଟା.
14ଟା.
My lord.
Your money is still lying with them or it has come back?
None lying there.
Lying with them.
Okay.
Maybe it was. My representation at annexure.
Just 1
five.
minute, 1 minute. So many matters are gone. No?
Item 25 টা right?
25.
My lord.
তারপরে next chapter.
Yes. 25.
My representation at annexure 5 millions at page 14. My lord, the
Annexure 5
village
series pending.
temple, Durga temple was locked by some miscreants. My representation is pending for OP number 1 millions.
It's an endowment temple or non-endowment?
Well, it is now it is governed by
Make it clear if it is a private temple or endowed temple.
and though my lords, the temple situated on a private plot,
Oh.
but
So what is the status of the temple? Listen, there are two authorities. If it is a private temple, then reed court cannot interfere.
no, it's under endowment.
It is
endowment.
under, then why don't you approach the endowment authority? What the collector will do?
My lord,
He is not the authority there. Sorry,
Public-
incompetent.
Public duty of endowment commission को क्या approach
If it is a public deity, then endowment authority, he may, if necessary, appoint a interim trustee.
my lord, my
Find out options, find out options.
provision टा को check
Find out options. This won't do.
Yes.
On his own submission of learned counsel, the temple involved herein is a temple under the endowment authority. In this circumstance, this court find no representation will work. Representation made to collector of the district will work here. Petitioner were permitting to withdraw the writ application, directed to find out the option available to such petitioners and move accordingly. Please. You would have some point.
Please hold on. सबका case.
You go to 30.
Item 30.
May it please your lordship notes. In this case, my lords, the petitioner is primarily challenging. And
Again,
because the documents, the annexure of those documents are voluminous, so I had to file it, my lords. I'm
could
sorry
have
for
been
that,
in
my lords.
volumes. It could have been in volumes.
My apologies,
Never
my lord.
filed such heavy briefs.
My apologies, my lord. Lords,
Yes, what is the case?
Yes, madam. The petitioner here is primarily challenging annexures 6 and 8. There's been a mistake in the prayer, my lords. By mistake, I have
6 and 8
written
are
annexure 9, my lords.
6 and 8 are provisional attachment.
Oh, annexure 6 is provisional attachment. And annexure 8 is the show cause pursuant to the page 123 to 126. 167, my lords. 167, 123 to 167. Annexure 6. Again, annexure 8 hoche page 1000 to 1060.
Provisional attachment.
Again.
And annexure 9 is?
Annexure 8. Sir, by mistake, I have written annexure 9 in the prayer. It is actually annexure 8.
8.
Again, it is my mistake, my lords. My apologies to that.
Oral submission and counsel for the petitioner to bring necessary correction in the prayer 8.
Again.
Body ଭିତରେ share କରୁଛନ୍ତି କି?
Body ଭିତରେ annexure 9 ତ ନାଇଁ ନା body ଭିତରେ same ରହିଛି correction କାରଣ annexure 8 annexure 8 ଏ typing ରେ ମୋର annexure 9 ଭୁଲ ଲେଖା
only in prayer.
In the prayer, my lords. Again.
Okay. Come to page 123. So annexure 8 is page?
Annexure 8 is page 1000 to 1016.
Come to page 123.
Again. Well, page annexure 6, page 123, my lords. My primary ground of challenge, my lords, is that the opposite parties could not have issued annexure 6 and annexure 8 after the petitioner company has been brought into corporate insolvency resolution process pursuant to an order passed by the null and NCLT, wherein a section 14 moratorium is being pressed now. The act under the IBC says, my lord, that once a
So
second.
there is a statutory
I'm sorry.
proceeding pending.
Yes, my lord. It's a proceeding, my lords. The law on this fold is, the Supreme Court has held that once there is a 14th proceeding, all proceedings are prohibited. my
It
lord.
is as good as this Company Act proceedings.
Yes, my lord. The section 2018, 2020, 2021,
how-
all
how
judgments are there to that effect, my
sustainable?
lords.
My lord, two acts are separate. I have given three
No,
judgments.
two acts may be separate, but
Yeah.
once it has
No.
gone under section 14, do you still exercise
Yes, my
attachment
lord.
orders?
Yes, my lord.
Then what the other authority
My
will
lord,
do?
we are not taking away the property. We are only attaching the property so that it will not create a third party interest. IBC, the NCLT will decide who will get. Only we are to protect the property, we have issued the attachment order.
Then what is the reason? What is the reason for provisional attachment?
Reason, my lord, a term loan was taken for a specific purpose. That money was transferred to different
Money laundering. There is allegation of money laundering.
Yes, my lord. That loan was not utilized for that purpose, and that money was transferred to different accounts of the company, where other bank loan is pending around 2,600 crores. Yeah, and
What is the money involved here?
my lord, under our money originally FIR was registered on 62 crores. On investigation, it is also found that 2,000 some odd crores has been taken away from State Bank of India, and that has been declared NPA, my lord.
Now, which bank involved here?
In
This
our
is attachment of which bank?
Central Bank, my lord.
Central Bank. Original FIR is Central Bank, my lord.
Central Bank, what is the amount involved?
62 crores.
62 crores odd, my lords.
What is your amount lying there?
My lords, we have, by way of an OTS under Annexure 2, page 36, the amount has been settled at 51 crores. Additional 40, we had taken a loan of 62 crores and odd, my lords. We had repaid 11 crores and 63 lakhs, my lords. Since there is a dispute between the petitioner and Madhya Pradesh Road Transport Authority, resultant the arbitration is pending. A civil dispute is ongoing. We then there was an OTS between the parties, my lord, wherein a no due certificate was given to us, closing the entire amount due. 51 crores was paid, my lord. There is no amount due and payable today, my lords. Annexure 2, page 36, my lord.
That may be you may be settling the
there is no amount
the
due.
counterpart. But what will happen to the government undertaking the ED excise? Money laundering aspect.
They are saying that there has been proceeds of crime, my lords.
Yes.
May I bring it to your lordship's kind notice, my lord? The properties that they have instead, 90% of properties are pre-loan, my lords. That they have also not looked into. I am not going on the merits of the fact.
Then why
I
don't
only
you
point that
why
before
don't
lordship.
you go to the authority for
My lords,
releasing
may I?
those properties?
The reason is, my lords, once a 14 comes in, the other proceedings cannot be. The reason why, as my learned senior puts in, we have gone into attachment to protect it, my lords.
No, now as you say, there are properties involved which should not have been involved. Properties acquired prior to loan should not have been involved.
Yes.
So why don't you raise an objection
No,
here?
so that may answer, my lords.
Yeah.
The issue that I have brought in here, my lords, is not whether the initiation was right or wrong. My point before your lordship is that they could not have proceeded post section 14. They cannot proceed in law because today a resolution professional is there who is operating the company. I am not doing it. The resolution professional is doing it. 1, 2. Today, the management is being run on day-to-day expenses are to be incurred. The CIRP cost account has also been attached by them. They cannot do that.
You can request them. There has been additional properties unnecessarily attached, and you release these properties.
But they have
now we are
everything.
on bank account.
No, all the properties and bank accounts also have been attached.
So bank properties, it will be taken care of.
Right.
But bank account,
They
you
have
say
attached
you are
it,
unable to operate.
Yes, my lord.
Then what is the amount involved, Mr. Agrawal? What is the amount involved? How can we attach the bank account
Your
entirely?
lordship, kindly see page 125. How fraud has been perpetrated.
No, that is, listen.
Yes,
Mr. Agrawal, never argue.
Yes, I understand.
Never argue as if it is a Supreme Court judgment.
No,
We know what the ED is doing.
No, my lord, I cannot.
Yesterday, you have got a bank from the Supreme Court also.
Yeah,
You are terrorizing people.
No, my lord, I cannot. Actually, I'm.
No, you
sorry,
are submitting as if a judgment has come.
No, my lord.
It is your observation.
Yes,
it is
yes.
in investigation.
Yes, it is investigation.
So there is no fact finding here.
It's an investigation stage.
Investigation is completed or not? It is provisional attachment.
It's a
Investigation is
not
yet to be completed. Why you penalize people? Let them give bank guarantee. You allow them to operate their bank accounts.
I am an.
Just 1 minute, Mr. Agrawal,
Yes, my lord.
you want to secure the money. Okay, let them give bank guarantee to that amount and the bank account will be operationalized.
One small prayer, my lord.
Subject to lordship, I am a resolution professional. I am neither the managing director nor the director of the company. I am a resolution professional appointed by.
You are the?
I am a resolution professional appointed by the NCLT to manage the day-to-day affairs of the company till a successful resolution plan.
Then why don't you carry this dispute to the NCLT?
I read petition is mentioned because they have come up in a proceeding against which the NCLT has already passed an order holding that the resolution professional is appointed. Then subsequently,
So you are
NCLT has already stayed this proceeding.
You are virtually a court guardian.
Yes, my lord, virtually in that manner. Because I now control everything. Ultimately, when the new resolution applicant, successful applicant is allowed.
Then unless the company gives a bank guarantee, you can't be allowed to operate.
But the operation can only be done by the resolution professional. No one else can operate the company till the resolution plan is successfully accepted by the NCLT.
Where is the appointment of resolution?
Yes, my lord. That is the lordship will kindly see. Page, my lord, 100. I'm sorry.
After recess. After recess, no further.
Page 111.
After recess, take up.
Sorry.
Mr. Agrawal, find out if he is already appointee custodian.
May I small prayer, my lord. It says he has come up against a show cause notice. I have given a judgment. Against that order, appeal is provided to the, he can approach the file show cause, raise all things, let adjudicating authority decide. And there is appeal provision under 26
And
of
then
the.
High Court, then Supreme Court, all these
No,
are there
not
and the party will be ruined.
No, I am not on that. That is the law, my lord. I have given a judgment
That's
of.
never the interest of the nation.
No, my lord, it is in.
They are to grow, we are to grow.
What my lord Apex Court has said, I have given 3 judgments. In Barsana Steel, the similar question was raised, my lord. And NCLAT said, no, both are independent. They can raise this issue before the adjudicating authority. Matter went against that NCLAT, my lord. Matter went to the Supreme Court. Supreme Court confirmed NCLAT order. Another judgment I have given of Delhi High Court, my lord, where also same issue raised, that they can raise all issues before the adjudicating authority.
Have you examined in those cases whether a court receiver has come or
Yes, my lord, section 14, same moratorium.
Same moratorium.
Same moratorium, my lord. Same moratorium order was passed.
All right.
I have given 3 judgments, my lordship
The
is to
High Court
consider.
judgment that Malayan Senior is referring to, I would say with great respect, it's per incurem because they have not at all referred to any of the judgments of Supreme Court, which lays down section 14 provisions, which is very wide and cannot be interfered, cannot be curtailed.
Whatever you are arguing, that is final adjudication.
Sorry, my lords.
Not for interim purpose.
Sorry, my lords. My apologies.
Judgment will have application or not, can I consider at this stage?
Does that
This
Mr.
stage
Malayan
I am
Senior
on the-
referred to the Delhi High Court? So I said, I'm sorry.
And you have come in a provisional attachment order. So as he rightly said, you have the scope of objecting. And if that is rejected, you may come to High Court. Examine that.
The whole purpose of section 14 would be obviated if no one will come to purchase the company anymore, because once they know that the attachment is there and then the company cannot proceed in a.
Attachment is not going to be quashed. It's a provisional attachment.
So once.
Therefore, there is further scope there. You may raise objection, it may be.
But then 32A will come into play, my lords, which says that the criminal proceedings will obviate once the resolution plan is accepted and process goes ahead. That is also there in the Act, my lords. I'm sorry, that is also there in the Act, my lords. IBC, under the IBC Act, my lords, section 32A, my lords.
NCLT.
Sorry, my lords.
Your engagement by NCLT.
Yes, my lord. Page. My lord should kindly come to Annexure 4, page 110. The relevant portion is at page 116.
Yes. Just read that.
My lords, page 116, my lords, para 13, we therefore consider it a fit case for admitting the petition and for initiation of corporate insolvency resolution process in respect for the corporate debtor.
Para?
14, in view of the aforesaid.
Para 14.
Sorry, para 13.
Yes.
Page 116, para 13 again.
Yes, admitting the petition.
Again, para 14, small b. Orders, there shall be moratorium under section 14 of the code.
No, who is engaged then?
C, Mr. Udanaran Mitra. He is the resolution. Small c, page 117.
Small c.
Again, he is the resolution professional.
Read that. Yes. Please read that para.
Mr. Udanaran Mitra, having addressed so and so, is hereby appointed as an interim resolution professional.
Small c.
Again, small c, page 117.
Oh, 117.
Again.
That is E.
14 the small c again.
117 E.
That is E, madam.
I'm sorry.
You say C.
My apologies.
So Udanaran Mitra, so and so having address at so and so,
Nahin.
he is hereby appointed.
But
But
as
who is moving this writ petition?
I am through him. He is the one who is moving it, my lord.
No, then he has to apply.
Well, he has applied, my lord.
No, ARSs are applied.
No, the company has to be there because the company will not go away. Who is managing the company? It is a resolution professional who is managing the company. It says he is hereby appointed as an interim
So
resolution
individual has been appointed.
as the resolution professional for the company because the directors will
That's
know.
right.
Thereafter minutes. Thereafter it says
Yes.
of the corporate data. The corporate data is ARSs, my lords. To
That's
carry out
right.
the
That's
functions of the
therefore
court.
the corporate debtor will not come to court.
No, my lords.
Now,
Corporate
who has come? You
the
see?
corporate debtor will come, my lords. He is the one who will come, my lords, because the resolution professional is managing the corporate debtor.
No.
Again.
Even if we presume that he is the custodian presently,
Again.
then he is to approach if he finds any difficulty in running the bank accounts.
Because he is the one who is running the operations of the management as on date, my lords. Because he is the one who can do it. No one else can do it.
So why he is not coming?
But he is coming through the company, my lords.
Through it, no company cannot come.
My lords, only he can come. No one else can approach, my
Who
lords.
has come? Infrastructure projects.
Yes, my
Limited.
lord. Through the resolution professional, my lords.
It should have been all right. What?
My lords, kindly see the
That
cost
may be
title, my lords.
technical difficulty.
Kindly see the cost title.
Now your interim prayer is final prayer.
No, we are only asking that till the resolution process is not complete, that they should stay their hands.
There will be stay of unnecessary this impugned order.
6 and 8, my lord. 6 and 8.
6 and 8 or not?
Again.
That's the final order.
No, till the process.
No. So that will be amounting to final order. So they let them
Because
file
quashing
counter
was we have sought for quashing of it. Till that time, we are seeking for interim protection, my lords.
interim order will be as good as final order.
But then
No,
32
you
will.
have to understand
My lords,
that.
I get your point. My lords, then 32A will come into my protection, my lords. The reason being, the law as on date, as your lordship knows, my lord.
Any provision of law comes to your rescue, you may take advantage. Well, there is no issue.
Yes, my lord.
But
The requirement.
your prayer here, interim prayer here appears to be almost the same prayer. Final prayer.
May I answer, my lord? May I answer, my lord? Subject to lordship's kind consideration. What is it that we are seeking? All we are saying is that till the time the resolution professional is managing the affairs of the company, and till the time
But
the
these are
resolution
independent proceedings,
may
you have to
I
understand that.
may I answer? And the resolution plan is not approved, no proceeding can be initiated pursuant to an 14th proceeding going on. That is my submission, my lords. Today, what has happened, my lords? They have initiated proceeding. Fair enough, no difficulty.
Right.
But they have initiated attachment proceedings and show cause notices after the proceedings have under section 14 are commenced. CRP pending. So therefore, they cannot go ahead with it.
I understood that. There is no point in issuing, no issue in issuing notice even. Notice has to be go.
Again.
Notice has to be issued.
Again.
But question is interim order is as good as final order.
Well, because unless
can't be
because
granted
no one else will now come to pay even to come to the picture and be a resolution successful applicant, my lords. They will avoid, my lords. The entire process will fail, my lords.
I am issuing notice, let him take notice. Let him file counter, thereafter only interim order will be considered.
Unless there is a protection, then no one will come into picture because the NCLAT now is in session. Let's kindly see page 1044, just for a moment. 1044, last page. 1044.
Yes, 1044.
Again.
Annexure 8.
Again, annexure 10 again, sir.
Annexure 10.
The resolution plan had become successful. The NCLT held that no, it's not a proper plan. So rejected it and said liquidation is to be appointed.
I understand
We challenged
there
that.
is the issue.
We challenged it.
I understand there is
And-
the issue, but no interim order possible at this stage. Either you may move the adjudicatory authority who is undertaking annexure 8 exercise.
But then we will be subject to his process when the resolution profession can approach it.
Take notice, I am considering interim aspect only of counter.
Well, at least not to
And
take
that
any
will be
coercive
final
action
order.
pending disposal, not to take any coercive actions pending disposal.
What coercive action further?
Because
Attachment
the
is already
required-
there. Now
yes,
come back to the attachment order.
Yes, my lord.
Let us
My
see the
lord,
language.
my lord would kindly say page 164, the portion of the attachment order. Page 164. my lord. 164. Which forms a part of the attachment order, my lord.
Yes.
Page 164.
Yes. Now, therefore,
Therefore, I, Subodh Kumar, Deputy Director, Enforcement, so and so, hereby order provisional attachment of the movable and immovable properties for so and so, approx with interest accrued thereon on the immovable property with value appreciation thereof for a period of 180 days from the date of order under first proviso to so and so. Further order, the same shall not be transferred, disposed of, parted with, otherwise dealt with in any manner whatsoever until and unless specifically permitted to do so by the undersigned, my lords. Now, what he is doing is by
so
this.
therefore it is not attaching bank. It is not attaching bank. On the other hand, it is attaching your property to the worth so and so.
My lords, the properties, my lords, kindly see the previous pages, my lords. My lords, kindly see 158, page 158. These are the properties that he's referring to, page 158.
These are properties.
Again.
Therefore, there
And
is
the bank, my lords,
therefore,
movable properties, again, immovable,
No,
page
no.
158.
just now you were reading movable and immovable
Again.
properties worth 21 crores.
Again.
21 crores.
Again.
Or in the shape of bank balance of rupees 9 crore 36.
Again.
So what is your bank
Bank
account
account,
now?
kindly see page 161.
No,
That is bank
only
account against
partial
that
attachment, not whole other attachment.
Bank account joda achi, seta page 162.
What is the amount lying there? What is the amount lying there?
My lords, the amount is more than 8 crores, my lords. Because it says here, say page 162, dekhle clarity hiji, 162. Clarity hiji again.
So now
Because
come
they are
back,
saying that
now
it
come
is,
back, if I
they are
state
saying
this-
CRP account. They cannot even do that. They are saying specifically CRP account. Again,
Then why don't
page
you,
160.
why don't you bring an objection to them? I can direct them.
Sorry, my.
Why don't you bring an objection to the provisional attachment? That a proceeding is going on, therefore you can't attach now.
So that I have bought it, my lord. They did not consider it. I'll show you, my lords. They did not look into it also. Page,
What is that?
Just page 120, 120, page 120. That I have bought it to the notice. They did not look, in law, they could not have done it. Page 120.
120, have you moved this authority?
Yes, my lord. Kindly see, my lords. It's before the Assistant Director, PMLA, Enforcement Directorate, Bhubaneswar General Office. My lords, page 120.
Yes.
119 se among notice dile, 120 amount dilvega. Because this was intimated to us.
No, it was
This letter
submitted
is
when?
issued, sorry, page 120.
It was submitted when?
Well, this was submitted on 1st of February 23, my lords. 1st of February 23.
After this annexure 6?
Yes, my lord.
Yes. So why are you not taking a decision on that?
My lord, this reply is pursuant to a notice at page 119. A notice was issued to IBI Bank to furnish the details. In that notice was not issued to him.
But it is not a response to annexure 6.
No, my lord.
No.
No, it's not in response to annexure 6.
The
my lord.
annexure 5 was issued to the bank. Bank intimated us, please intimate the concerned authorities that they have issued this letter to us. So based on the bank's
Yes,
intimation,
bank being
we
constituted
immediately,
there to oblige them.
because bank understands that we are under CRP. So therefore they intimated us to please intimate them.
Okay.
So we immediately responded that the letter in response to the affirmation notice
take
issued
notice,
by your
but-
branch
You take
Head-
notice, the interim aspect will be considered after the counter only.
My lords, they have put up the adjudicating order on 20th. So at least an adjournment be granted on that, my lords. At least an adjournment be there. So that lordship will decide, at least that be there, my lords.
What adjournment?
My lords, they have put up the date for a hearing on the show cause on 20th. At least we may be permitted to file an application.
Why? Let them take that decision.
But that once they take that decision, my lords, property stands attached, then no one will come in for buying the plan.
No,
No
he
one
has
will come in.
not
Everything
filed-
will escape, my lords.
Sorry.
It will be a 14th thing, then the entire 14 will go away, my lords. IBC will get defeated by a 2002 act, which is a subsequent act of 2016. And law is well settled that 2016 code is so wide that
No,
it
you
cannot be
can't-
interfered
you
or
can't
curtailed.
You can't completely take away their jurisdiction. There is a money laundering aspect also involved.
But that is to be with 32A, which is
Therefore,
post.
you can't take away the jurisdiction completely.
But we are not on that, or as of now, we are not on that. We are only on the point, my lords. Can they proceed post that? That is the only issue lordship has to decide. Whether that
You
is
see,
right or wrong, it is a
both are-
subsequent.
If both are independent issues, both can proceed.
My lords, there is a judgment, my lords, like my lords,
So
scenario.
therefore, final adjudication is necessary. That judgment is a final adjudication, not interim order.
My lords.
You are not understanding
I
that.
bow down to the my lords, I bow down.
So take
Unless-
notice, take
At
notice,
least
let them file counter. If you desire, I will permit you to move vacation court.
My lords, no, my lords. Before you
Also notice on the question.
only
of
an
partition.
adjournment if possible, subject to lordship kind consideration.
He has
Ah.
not filed so cause till now. So
That's
cause
what
has
they are
not.
asking.
No, they are challenging at the threshold.
Challenging. What
Therefore-
my friend was proposing,
Therefore, you.
so for adjournment, he has not filed till that so cause has
Mr.
not.
Agrawal, you
Yes.
are also to be keep on mind.
Yes, my lord.
There is a NCLT proceeding
Yes,
pending.
my lord.
There is virtual appointment of a receiver, so to say.
Yes, my lord.
So that means you will not allow the NCLT to operate even.
Yeah, no, my lord. We are, NCLT will proceed independently, my lord.
Then how he proceed? ଆପଣ ଏଇ ଯୋଉ କରିଲେ ଯେମିତି ତାକୁ ନେଇଗଲା ମାଗିଲା ଆଶୀର୍ବାଦ ଯେ ସେ ନ ବଞ୍ଚିଲା ମୋ ପିଲା ଆସିବ
My
ଶହେ ପିଲା
lord,
ଜନ୍ମ କରିଦେଲା।
we have to also protect
therefore-
the interest of the creditors, my lord. We are not taking away the money. And
You are not taking away, but that money is worthless. You are already attaching the bank account. What you will do?
my lord, otherwise the money will be siphoned off. If your lordship looks to that attachment order, my lord, how money has been diverted, your lordship will find it, my lord. From one account to 10 companies floated different.
Okay, you file your objection.
Yes, my lord.
You file your objection.
So the resolution professional cannot do it, my lords. The directors are no longer there.
The main prayer also involved as interim protection, but however, keeping in view non-grant of interim prayer may result making the proceeding before NCLT infructuous, inoperative, otherwise inoperative. This court feels it appropriate to hear the submission and counter if any, and look to see the counter if any of the enforcement directorate by the next date. Let the counter if any be filed within 2 weeks. A response if any also be filed within 1 week. Place the matter on 22nd of June.
My lords, lords, a prayer for adjournment may be considered. That is all I'm seeking for. My lords, 22nd June we come here, my lords. 20th is the date fixed. All I'm praying, and adjournment. That is all, my lords.
Challenge of the party to the initiation of proceeding at the threshold to be considered in the present writ application in the event the petitioner applies for adjournment before the
adjudicating authority. My lords.
authority
PMLA.
on the issue involved herein. There shall be adjournment of such proceeding till 26th of June.
Deep level, my lords.
এটা নেই যে পোকা বাকি ফাইল দিন।
My lords.
Yes, next.
Item 31.
It's no big matter can be taken today. I'll be rising by 3 o'clock. Only fresh admissions will be taken up.
31, my lord, SRP case is pending, my lord.
Mike ଟା ଟିକେ ତଳକୁ କର। Yes, କଣ ହେଲା?
SRP case is pending, my lord.
SRP case is pending at a fresh admission.
Yes, my lord.
Yes.
32 also same, my lord. CRP case.
Same.
Yes, ma'am.
32 case number change.
Obliged.
Item 33.
My lordships. But here, the petitioner challenge the annexure 3, which was issued by the, that is the, that is approved by the collector and other authority for a projects, but the, which is the, during pendency of the first project, that is Lakshmi that the government had sanctioned some money under the Pradhan Mantri Adarsha Grama Yojana. 30, as per the scheme, the money will be sanctioned to the panchayats where the 50% to above 80% are there, Lord. According to panchayats have been selected, that is called the annexure.
Who are you?
But I want one of the villager of the Panthar Bent, Lord. Ward member, Lord. Yeah, that is the project work, Lord. And that is to be Lord, annexure 1, page 12. Page 12, Lord.
Project as per the project.
Yes, but two panchayats are selected.
Who is to get money?
Money is to get the Panthar Penta village. Annexure 1, page 12, Lord.
No, villagers are the panchayat.
Panchayat will get that money will be executed in the panchayat as per the sanction of the government. Lord, page annexure 1, page 12.
Why you have come?
Blood. I am the one of the villagers of the panchayat. That is the Panthar Penta panchayat.
Maybe Bhadrasan of the panchayat.
No.
Sarpanch is there.
Blood. Why I am saying that 40 lakhs was sanctioned for the panchayat Panthar Penta. 50% of money has been executed in Panthar Penta. After when the matter is pending and the money was that is work is under progress, Lord. Annexure 3, page 17. The authority sanctioned another project work to execute the 50% work there, Lord. And the money is pending. The executants are not, that is some executants money is pending, bills are pending. When bills are pending in one works, Lord, that are divert to other works.
Work is completed. Or
no, not completed. That is your problem. 40 lakhs are sanctioned. 20 lakhs are executed. Out 20 lakhs are sanction divert annexure 3. Political dispute, nothing other than that.
Who are you? Why you are poking nose there?
I am the
it is the Bhadrasan of the state authority or the Sarpanch.
No, it is a public work. That is the
public work. Then file a PIL.
No, sir.
File a PIL. No individual interest involved here.
No, sir. Muko question sir. It is sir 40 lakhs sanction is government work.
Who are you? Why you?
I am the ward member. I am the ward member of the
Panchayat. Ward member has not come here.
Yes, I am ward member.
No,
I mentioned that.
You may be ward member. Ward member has not come here.
No, blood, that is yes. Blood.
You are in individual capacity. You don't have any interest.
Blood, may pray one thing, Lord. Lord, may directly go. I will make a report to the collector.
No, you are in no capacity.
Then Lord, may report that to PL matter. That will be converted. That is converted.
You may seek appropriate advice. I am not there.
But it may be converted to PL.
No, sorry.
Otherwise, the money will be sanctioned.
The application it appears the petitioner as an individual have no locus.
Then Lord, I have permitted to withdraw to file better
At
application.
this stage of the matter, Sri Patnaik seeks withdrawal of the writ application to pursue any other remedy if available.
Item 34.
Okay, item 34, my lord. Annexure 1, the requesting application pending before the.
Yes, Mr. Sahu already covered. Annexure 4 is.
Annexure 4.
Same Annexure 4 and 1 both are relevant here. Or here Annexure 1 only.
Annexure 1 legible copy not Annexure 1 order passed by the
revenue. One has to be disposed of.
My lord.
But there some pleading, other pleadings were there. He was taking support of some other document.
Some other document is
Annexure 1 pending before competent authority. And Annexure 1, what is your request?
Annexure 1 is the order passed by the revenue authority.
No. It's a representation.
My lord, in this case.
Annexure 1 is a representation. How do you say it is order of the competent authority?
No, my lord.
So what is that representation?
The settlement of the
settlement of it. Settlemental.
On the basis of order passed by the revenue authority.
Why do you make a representation? This may be treated as a petition for settlement. Okay, considering the contentions raised herein, this court find Annexure 1 can be treated as a petition for settlement of the land involved therein. And again, then there is difficulty. This will be a settlement order OPLE. This is a settlement order OPLE.
In fact, issuance of ROR on the basis of K4.
Then why he referred to encroachment order?
68.
No, what appears here to be, there is already encroachment order.
Yes.
Now he wants to settle that land in his favor.
Yes.
Therefore, that settlement is a possibility only in the OPLE Act.
OPLE Act.
There involves the provisions of OPLE Act. Ministry directed to list this matter with the OPLE assignment. Yes.
Item 35.
Item 35, my lord. The petitioner is seeking a direction from the Honorable Court to the OP number 1.
If the consolidation miscase is admitted.
Yes, my lord. It is admitted on 24/20/2022.
Consolidation miscase 12 of 22 is already entertained. Provided notice on the opposite party is there is sufficient. The collector cutter, OP number so and so is directed to undertake the desired exercise by completing such proceeding at least within a period of 2 months, but however involved in the parties likely to be affected. Yes.
Item 36.
Thank you, madam.
Maybe.
Yes.
Yeah, my lord. The petitioner seeks to challenge the action of the opposite parties number 2 and 3, making construction of a house in front of my plot, and that is over a public road, my lord. My lord, annexure.
So you have
2,
raised a complaint pending before the commissioner.
my lord. Till that date, my lord, they have already proposing to start construction, my lord.
Private party involved?
No, my lord. Only
Then
municipal.
who is undertaking the construction?
2 and 3 municipality, my lord. That's a government road. I have given my some of the land I have given my lord ROR.
Then who will consider your representation?
Already.
Municipality will consider.
Consider till that date, they may not start the construction of the house, my lord, that time.
Hey, that's right. Who will consider? You have an allegation against municipality.
My lord. And there,
You ask municipality to consider your issue. You have a civil suit pending.
civil suit with respect to the private party, not with the municipality. They were trying to encroach that land in front of my land, make construction of houses. So that is civil suit is pending with that private party.
Therefore, Annexure 4 is pending before opinion of directed to be given lawful disposal by working out within a period of 2 months, however involving parties are affected. Yes.
Until
Item
there,
37.
my lord, till that date, no construction.
No interest. Sorry, implementation pending the interim order. Yes, next.
May I please, man.
That's
The mutation appeal is pending before the sub-collector mail opposite party number 2. In the meanwhile, my lord, one demarcation case has been filed by the opposite party number 4 with regard to almost same land, my lord.
Section 15B is pending.
Mutation, my lord, mutation appeal before the sub-collector, my lord. And till then, my lord, demarcation case, your lordship has in earlier writ application, the opposite party number 4 has approved this honorable court, and your lordship has directed for the disposal of the demarcation case. Taking advantage that order, my lord, the appeal is pending, but the demarcation case is proceeding by your lordship's direction, my lord. Now the one notice, it came to the knowledge of the present petitioner.
The ultimate outcome in demarcation.
My lord.
It's only demarcation of land.
Yes, my lord, only demarcation of, but so but the demarcation of land is the subject matter of mutation appeal is also the subject matter of demarcation case, my lord.
Same land involved.
Yes, my lord, same land, my lord. So your lordship may say that appeal be concluded within a certain period. Till then, my lord, demarcation case may not be.
Then I am to involve other parties.
Yes, my lord, I have given the, I have made him party also, my lord, murder party also, my lord.
By your allegation, it has been brought to the notice of the court that decision for an outcome in demarcation case 152 of 22-23 is taken in suppression of material fact like pendency of mutation appeal involving same property. In final attending to the WPC 11502 of 23.
Yes, my lord.
In final adjudication of WPC 11102 of 23. Considering the serious allegation, okay, it is also alleged in the event the demarcation proceeding gets concluded. Such decision may respect the ultimate outcome in the appeal pending. This court will intend to to reproduce as follows. In the meantime, in demarcation exercise, pursuant to direction of this court, in demarcation proceeding number 10.
My lord.
Demarcation proceeding number 1.
Demarcation case number 157 and 2022-23.
157.
157, my lord.
नहीं तो किंतु नोटिस टा देखिले पेज 32 रे
Page 32, my lord, notice also.
1076
No, that is a notice number, my lord.
Notice number.
Demarcation case number 157, it is there, my lord.
That's notice. Pending before
Pending for Tahsildar, my lord, opposite Patna 3.
number 3 till next date hala.
Obliged, my lord. I love it.
There shall be stay of further proceeding in demarcation. Place the matter immediately after service of notice and open motions. Yes.
Item 38.
May please your lordship.
A free copy they do. Free copy to State Council.
My lord.
38.
My lord, lordship may dispose of this matter in the light of judgment in Hon'Ble of the case, my lord. I am side.
Your appeal is still pending.
Appeal is, my lord, still pending, my lord.
Then he
Pending
will
before the
come.
OP number 3, my lord.
So in the appeal, he may involve this judgment.
Yes, my lord.
That's all.
In the my lord. That is the only.
Okay, considering submission of some issue, this court finds.
Pursuant to annexure 5, my lord. 5 series.
You have annexed as.
Yes,
Okay,
my lord.
Appeal 5. Appeal is annexure 5.
My lord, that notice is there, my lord. Annexure 5 at page
Notice
23.
in the appeal is annexure 5.
My lord.
Okay. On this
23, my lord, page.
There is pendency of appeal. Appeal number.
At number 23.
1272 of 13.
My lord.
Before OP number.
Before OP number 3, my lord.
3.
My lord.
Petitioner, while seeking direction for early disposal of such appeal, also seeks a direction to the appellate authority for taking into account a decision of this court in WPC number 1608, along with many other petitions of 2014, along with several other petitions decided on 2/1/23. Okay, in the disposal of the writ application, this court observed, while directing the appellate authority to conclude the appeal proceeding at least within a period of 3 months, permit the petitioner to bring to the notice of the appellate authority of the judgment referred to herein for its consideration in the appeal proceeding.
Obliged, my lord.
Next.
Item 39.
39, my lord, same matter, my lord.
Same.
Same authority.
Here the appeal number, what do you
Appeal
find?
number, my lord, 1271, my lord.
देखिए
1221.
All right.
Obliged.
Item 40.
Item 40, may I please, your lordship. Lordship, I am challenging the inaction of the opposite party number 2 in implementing their own order, demolition order. I'm for the petitioner, your lordship.
There is no writ petition pending against that order?
No, your lordship.
Okay, you serve copy.
Yes, your lordship.
It is on municipal corporation.
Yes, your lordship. BMC.
Okay, then you have to take notice. It's a notice.
In the meantime, I have filed the IA, your lordship.
What will be done in IE? It is
To-
for their
to stay- to
execution. Why should High Court pass an interim order here?
Your Lordship, the opposite party number 3 is continuing the construction work despite the court order.
That's right. Let them appear. We can know the reason why they are not executing their own order. Or else I may direct annexure 2 may be worked out if there is no
Yes, your
legal
Lordship.
impediment.
Yes, your Lordship.
Municipal corporation also. At the submission of learned counsel for the petitioner. This court find the direction sought to be is against municipal corporation Bhubaneswar. Considering the allegation of non-execution of, where is the order of demolition?
Your Lordship, annexion
Oh,
to
page 11.
page 11.
Okay, non-execution of the order passed by the OST bracket OD Act by annexure 2. Petitioner is seeking a mandamus in working out the same. This court record the statement of learned counsel for petitioner that there has been no challenge to such order in High Court by party agreed. Okay, in the above circumstance, this court disposes the writ petition directing the competent authority to execute the order at annexure 2, running page 11 of the brief within reasonable period, provided however there is no stay of such order by higher forum.
Obliged, your Lordship.
Yes, 41 will take some time, Mr. Para. I don't have time now.
First, sub-item, my lord, my limited prayer would be my disposal of a representation at annexure 5 series.
Sub-item 1, my lords. That, my lords, what happened? He applied for auction.
Therefore, let it come after vacation.
No, my limited prayer, my lord, let the secretary, my lord, consider my representation, then
Secretary-
pass any other order.
But
For
secretary-
at page 46, your lordship may see.
May I submit? Secretary, my lord, this is a case, my lord. Auction was
Why
held.
you enter into merit? You
No,
want.
I am not entering into merit, just to point out for matters proper appropriate order matters. The auction was made, he participated. So
I have no time to hear.
No, only limited prayer, my lord, let the representation.
He only says the representation at
Yes, at
annexure.
that
annexure 5
exactly,
series.
that exactly I am
Sir,
pointing
Annexure
out.
5 series.
That exactly I am pointing out, secretary he is, secretary only VC को देवे.
Okay,
Also after vacation.
VC को देला VC कर.
okay, it is VC को पकड़ रहो.
हाँ, VC secretary has no authority. VC में कर.
No, I have entrusted
Annexure
to
5 काहे देइछे?
Secretary
की देची. So the secretary may forward it to the VC, my lord, and let the VC
If he finds inconvenient, he may forward it to
forward the
VC.
VC.
My lord object.
Or else, if he has no
Let him
jurisdiction, he may pass lawful order.
Let him file the detailed
And I have
representation.
already
Course
filed.
of hearing, seeking a direction for disposal of, giving lawful disposal to annexure 5 series. You are placing 16459 of 23.
Malas.
See, Mahapatra raises objection on the competency of the authority to whom the representation involved addressed and says it is on the other hand. The VC is required to.
May not observe, may not observe that.
Secretary
का power नहीं. अपन तापर order टा अपन.
Sir, बाकी ये ठीक है, seeking direction for disposal of the annexure 5 series. Considering representation at Secretary VDA, OP number so and so, pending by the annexure 5 series, this court in the disposal of writ application directly Secretary or competent authority, if any. To give a lawful disposal to the request of the petitioner by the annexure 5 series.
5 series.
By completing such exercise within a period of 1 month.
The personal hearing if necessary. Personal hearing if necessary.
Okay. Also providing personal hearing opportunity to the petitioner. On a date and time being fixed and communicated to the petitioner in the meantime. Aro case ta kon?
Aro dita case.
Aro dita interim order achi, let it come after vacation.
After vacation, interim order to continue second case.
Only किसी पैसा मु दे देता already 10% मु दे दीजिए. they माने कहते there is a belated
All right,
payment of this
if my lord friend wanted to deposit some money.
No, I want I have already deposited that
Already
10%.
deposited, he says.
No, no, खाली initial money टा EMD टा deposit करछो rest of the amount if minor and what
देबे आपण जदि डायरेक्शन देबे से करिवो कोन?
हां सेटा कोन देखि तो एटा तो entry order टा अछि
In the second case,
second and
In
third
the second and third जो दिखा है।
dita का आसीबो after vacation हला.
interim order तो अछि
Interim order if any be continue.
सेटा without leave of the court hitla.
हां सेटा मु instruction
Action without leave of court.
Court hitla.
से interim order टा continue करिवो.
Again.
All right.
Sub-item 2 or 3. Sub-item 2 or 3 टा is interim order to
2
continue.
and 3 रे interim order continue करिवो.
Obligation. Obligation.
Item 42.
Yes.
Without following any due process of law. Without following the due process of the Berhampur Municipal Corporation has demolished the wall of the petitioner and proceeding to demolish further manner.
Pardon?
And without following the due process of law, the Berhampur Municipal Corporation, they have demolished the wall, boundary wall of the petitioner. Now they are my lord proceeding further, my lord. That's the action I have challenged in the writ petition, my lord.
Challenge ले कोन proceed तो करि सरलेनी.
नहीं पुणी proceed करूचले भितरे भांगियाकू मु प्लान अप्रूवल करिकरी मु गोटे मार्केट कॉम्प्लेक्स तयारी करूची.
So you have a case against the government or against the
Against the municipal corporation, my lord.
but you also seek a request against state?
State टा करछि से माने डिमार्केशन कले
Prayer is
नहीं
it's
डिमार्केशन
all opposite parties.
नहीं डिमांड नहीं ऑपोजिट पार्टी स्पेसिफिक लिखि छेगा.
Which para?
पैराग्राफ 1 ने तो बरहमपुर म्युनिसिपल कॉर्पोरेशन और पैराग्राफ 1 में अछि ना.
This is a photograph of which date?
Again?
This
से आफ्टर भांगी दिछन 12/5
boundary भांगिले but
they are proceeding, my lord. से proceed करूथिले भितर को दा बंद करई छी.
it is your land.
आगे मु से देई दिछ ना.
रीट आसन जाउनांती सिविल कोर्ट को.
एठी तो हेइ जबो ड्यू प्रोसेस ऑफ
पब्लिक एक्शन आसीची ठीक अछि आपन जते राइट अछि गो एंड गेट इंजंक्शन.
मु तो एठी आगे से माने आसी कहबे जे whether they have followed the due process of law or not.
Repetition involves a serious allegation of following no due process of law and undertaking demolition as well as construction exercise over the own land of the petitioner. Plot kete plot number कोठे अछि?
खाता में पैराग्राफ 1 में
involving plot details so and so para 1 रे अछि. Yes, para 1 as per details in लिखि दो. Considering serious allegation of undertaking demolition and construction exercise without following law, this court is inclined to issue notice. Okay. In this case, the notice also once said. In the meantime, there may not be further coercive action involving the petitioner in respect of the land referred to herein above, without leave of the court. Yes.
Item 43.
43, my lord. I am challenging initiation of demarcation proceeding, my lord.
Initiation
They lost
of
the
demarcation.
suit. They have issued notice, my lord, and they have lost the suit, lost the appeal. Now they are in second appeal, and wherein the status quo order was granted. And my lord, in the meantime, I had applied for demarcation and a notice has been issued to me.
So you raise your objection there that the
I have
dispute-
filed, but they are proceeding, my lord.
Where is your objection?
Objection
That
is there, my lord.
proceeding
At,
involving same is pending in High Court.
At annexure 3.
Page?
Page 42, my lord. Para 2, your lordship may kindly have a glance.
So there must be private party.
Again.
Okay, through the read.
Lordship, let them append the stay order as well. But stay order has not been appended to the writ petition.
The status quo passage.
Status
It
quo,
is
where is that
order,
order?
that is, order has not been annexed, your lordship.
Where is your averment to that?
Averment also.
But a second appeal is undisputedly pending.
That is pending, your lordship.
So if a second appeal is pending, then Mr. Mahanti,
my lord,
what is the ultimate outcome in a demarcation proceeding?
By this way, my lord, he is trying to create disturbance in my possession. In fact, his father sold me the land. In my
Then why don't you get a stay order of this proceeding in the second appeal?
second appeal, they are not cooperating, my lord. They are repeatedly taking adjournment.
No. They may be taking, second appeal is in High Court.
Status passage.
Second appeal is in High Court. No, status quo, irrespective of status quo, there is no prohibition for going for demarcation.
No.
It is only demarcation. Somebody's plot will be measured in the involvement of the boundary tenant.
Okay.
There is no question of recovery of possession or delivery of possession there.
No, my lord.
Yes, you may have a case that on the self-same issue, a right title interest issue involved, second appeal is pending. So why don't you move the second appellate authority to stall this demarcation proceeding?
My lord, we are now in.
Tomorrow
it will be holiday, my lord.
Pardon?
Tomorrow it will be holiday, my lord.
ହେଇଯିବ କଲେନି ଆପଣ ଏଇ ସମୟ ଭିତରେ ସେକେଣ୍ଡ ଆପିଲ ମିସ୍ କେସ୍ ଆଣିପାରିଥାନ୍ତେ ନା ନାହିଁ ରିଟ୍ କାହିଁ ଫାଇଲ କରିଦଉଛନ୍ତି when the so see where there is no civil dispute pending a writ may be maintainable
civil dispute is
but undisputedly civil dispute is pending so why should we jump to 26
it is not one second appeal, two second appeals.
Okay, then it is doubly secured. So withdraw this and move the second appellate court.
Now they are creating disturbance.
Now
let him come, my lord, your lordship may kindly issue notice.
Then I will observe, even if the demarcation proceeding is undertaken, that should not be entering into handing over or disposition. Yes, I have the submission of land counsel for the petitioner and the state counsel. Matter is taken up at admission stage considering urgency. In the course of hearing, while alleging that on the self-same issue, a disputed property, there is pending second appeals with order of status quo even though there is no copy of such order, but however there has been clear pleading to this effect. It is at this stage of matter, this court find it would have been better for the petitioner to approach the second appellate authority for suitably modifying the status quo order. For there is threat of danger to the petitioner by way of demarcation exercise. Be that as it may, finding time constraint with the petitioner. This court says, disposing the writ application simple of while keeping view pendency of second appeal. Number kete?
Second appeal number, my lord.
513 of 16.
513 of 2016 and another is 514 of 2016.
514 of 2016. 13 and 14.
Again.
Yes. Subject to final outcome in the second appeal pending years. This court direct the demarcation authority in the event the demarcation proceeding is undertaken, there shall be only preparation of demarcation outcome in pen and paper. And there shall be no attempt for repossession or disposition of either of the parties. Disposition or repossession of either of the parties.
Urgent copy.
Item 44.
Item 44, may I please, your lordship. Your lordship, yes, the petitioner herewith files is challenging the order dated 14/10/2022 of the learned Lokayukta, where the Lokayukta had directed.
This matter was there yesterday.
No, your lordship, this is a.
No matter.
Yes.
All right. What the Lokayukta directed?
The Lokayukta had directed that the inquiry report that is submitted by the director of inquiry has ensured that no misappropriation of funds or any type of irregularities has been conducted. No misappropriation of funds or any type of corruption or irregularity has been committed by the concerned officials of the Gram Panchayat. The inquiry report is at Annexure 1 series. Your lordship may come to page 18. Page 18 of the inquiry, page 18 of the petition. Annexure 1 series.
Page 18, is it internal part of the preliminary inquiry report?
Yes, yes, Your Lordship.
No, where is the direction of the
Uh,
Lokayuta?
Page
Annexure
165.
Annexure 4.
165, Your Lordship.
165. Yes, read that also.
According to the complainant,
Their heart, read from their heart. According to the
complainant, huge amount of money has been misappropriated by Srimati Annapurna Deori as Sarpanch Mukundapur GP Sri Prasant Raut, Panchayat Extension Officer, and Shubhalakshmi Tripathi, Gram Rozgar Sevak of same Gram Panchayat, which was meant for public under various welfare schemes of the government. The complainant had admittedly contested the election unsuccessfully for the office of the Sarpanch Mukundapur Gram Panchayat against Annapurna Deori. Be that it may we took cognizance of the allegations made in the complaint and directed the Director of Inquiry to conduct a preliminary inquiry and submit the report. This we did in the exercise of the power conferred under Section 20, subclause 1, subclause A.
You are the Sarpanch.
Your Lordship,
Who are you? You are the complainant.
I am the complainant, Your Lordship.
Complainant. So there is a direction for conducting an inquiry.
Yes, yes, Your Lordship.
Then
In page number 166, the London Locator directed that the Director of Inquiry, after ensuring thorough inquiry into the allegations, has reported no case of financial irregularities or corruption is made out against Annapurna Deori and Prasant Raut. On perusal of the report, we also find
this is in direction of inquiry stage only. How are you affected now?
Your Lordship, there is irregularities in the
Right? Let the inquiry report come.
yes, Your Lordship, the preliminary inquiry report is
Okay, that preliminary report, he is satisfied. Therefore, he is now directing the vigilance to have an inquiry to arrive at a conclusion. You are going against you.
yes, Your Lordship. It is
What
close
you want? You want on the basis of P, the action should be taken.
on the basis of a fresh inquiry should be conducted.
The action should be taken.
I didn't get Your Lordship.
We want that there should be action by the Lokayuta on the basis of preliminary inquiry.
Your Lordship, the findings of the preliminary inquiry has not been considered.
Gone through, unless he is satisfied with preliminary inquiry, he is not directing vigilance for another inquiry. Now director is directed to have an inquiry and submitting the report. Why are you coming to High Court?
Your Lordship, they have also submitted an additional inquiry report also, where
You are spoiling your case only after vacation. You are spoiling
Lord,
your
sir.
case only.
But in this case, Lord, my name may be reflected in the court list.
Further inquiry report reveals, then he may suggest for recommendations. You are
Lord,
obstructing
sir.
your case only.
My name may be reflected.
So let it come after vacation.
Lord, item 4.
Portion
I
of
mean,
the
I'm
annexure
audible to
1,
Lordship,
the
Lord.
work order issued, and the petitioner fulfill the work mile, but not release the estimated amount.
Work order was issued when?
2020 mile.
20.
Yes.
So what was the period of work?
That is not mentioned. ପଲ୍ଲୀ ସେବା ନିଷ୍ପତ୍ତି କ୍ରମେ ଆପଣଙ୍କୁ ନିମ୍ନଲିଖିତ ପ୍ରକଳ୍ପ ଗ୍ରାମ ସମୟ
ଲକ୍ଷେ ଟଙ୍କାର କାମ କଣ ବର୍ଷ ବର୍ଷ ଧରି ଚାଲିବ କି?
ସେ ପଇସା
କାମ ସରିବଣି।
ହଁ ପଇସା ସରିଛି କିନ୍ତୁ କାମ ପଇସା ଦଉନାହାନ୍ତି। ଆନେକ୍ସର 2 ଟା ପେଣ୍ଡିଂ ଅଛି।
ପଇସା ଦଉନାହାନ୍ତି ଆପଣଙ୍କର?
ଆଜ୍ଞା ଆନେକ୍ସର 2 ଟା ଡିସାଇଡ୍ ହେବ।
It is alleged even though the work order annexure 1 has been worked out, there is no release of payment. এটা କଣ ବିଧାୟକ ପାଣ୍ଠିରୁ ଆସିଥାନ୍ତା?
ସେଟା ଗ୍ରାମ ଉନ୍ନୟନ ସଂସ୍ଥା।
ହଁ ବିଧାୟକଙ୍କ ପାଣ୍ଠି ସେ କାଗଜ ପତ୍ର କରିଦେଇଥିବେ ଦେଇ ଦେଇଛନ୍ତି ବୋଲି ଆଉ।
ନା ଦେଇନାହାନ୍ତି ସେଟା ଏମଏଲଏ
କଣ କହୁଛନ୍ତି ଦେଇନାହାନ୍ତି?
ଏମଏଲଏ ଫରୱାର୍ଡ କରିଛନ୍ତି ସେ ଚିଠା।
କାହିଁ ସେ ରିସ୍କ ନଉଥିଲେ?
ସେଟା ଏଟା
In any case, the petitioner has a pending repentation by the annexure 2, which again appears to have been already forwarded by the MLA to the BDO Bali Patna. Balianta for appropriate action. Or considering pending case, this court disposal of writ application, direct the BDO Balianta to give a lawful disposal to the request by annexure 2 by working it out within a period of 2 months.
Prayer court.
Pardon?
Prayer court.
Prayer court kariba. All right, prayer to ago.
Obliged.
Item
My lord,
46.
sir, am I audible to lordship, my lords? I have appeared to visual. The last case, my lord, in the cause list, my name may be reflected. In the previous case, my lords. The cause list by
Okay, that lokaito matter.
yes, my lord. In the cause list, my name may be reflected. I appear for opposite of
Apo
partner
power
five.
deichandi, you have filed your power.
Lord, sir, in course of the liberal.
Okay.
Already filed, my lord, but not in the records.
Okay.
For opposite partner five.
Lokaito matter ta after vacation koleni. Yeah,
My
purva
name may be reflected in the cause list.
46, sir. Sri Sangram Das.
44.
That is Pratik Das, sorry, 44. Sangram Das undertakes to file his appearance in course of pay. Next listing registry is directed to indicate his name. Yes.
Item 46, may I please, your lordship. Regulation 2 matter covered by your lordship judgment, my lords. Jamni Ramesh versus State of Orissa.
Accepting the form 2.
Lordship.
All right, same order.
Delay may be condoned, my lords. Delay, that may be condoned.
Pardon?
Delay.
No. Once there will be direction to accept form 2, delay is automatically condoned.
Obliged.
Item 47.
Same order.
Item 27, my lords, bifurcation of a my lords mauja. In the process, the natural drain and the hill, which is being used as grazing ground, is being taken away. In respect of that, my lords, the petitioners of the villagers, they united together and filed an annex of 2. My lord, kindly glance to annex of 2, page 13,
which is
pending before the collector. Also, may I pray, my lords, the collector may consider it, giving opportunity of hearing and take a decision, my lords.
Okay, all right. I had the submission of Mahapatar and counsel for the petition involved following prayer. At the same time, this court find the petitioners hearing. I have already a pending representation before the collector Ganjam, appearing at annexure 2 since 6th May 2023, considering serious allegations involved therein. This court, in the disposal of writ application, direct collector Ganjam to look into the grievance of the petitioners, enter into appropriate inquiry in the involvement of the parties likely to be affected, and give a lawful disposal to the annexure 2, working it out at least within a period of 2 months from the date of communication.
Till then, status quo
Order be handed over to.
Till then, status quo.
So as it is, representation consideration the status quo.
The thing is that if they will go,
1 month.
only thing is that in matters of categorical.
Okay. In the process of inquiry, if the collector feels there should be protection required till final outcome, it will be open to the collector to grant interim protection if any.
Item 48.
Please, your lords. So, limited prayers,
yes, 48.
Part number 5 not accept my application to record.
Pardon? Annexure?
Annexure 4, lordship. My application is annexure 4.
What happened? Why he is not receiving this?
Not receiving.
Application ASO receive the covered order. Alleged annexure 4 application could not be received even by the ASO. This court deprecating such attitude, disposing the read permit the petitioner to retender such application, and competent authority on accepting the same will pass lawful order on the same.
Item 49.
May I please, your lordship?
Yes.
Here the by virtue of your lordship's order at page 34 of the present writ petition, they have issued the passport, renewed the passport. That renewal of passport is at page 49. But at present, Again, I have booked a ticket.
What are you challenging here?
Not
Refuse to grant passport.
refuse to grant
passport has been
visa for the present tour, even though my passport is valid till 1st December
Where is
2023.
that refusal order?
No, they have not issued any written order.
How it read
The day before yesterday only, I have booked a ticket, your Lordship may see, because
might be booking ticket. What your challenge aspect is not involving here.
only by wrong interpretation of page 45, they are not renewing, granting the visa. Page 45, your
They are
Lordship.
not granting. Where is that?
That
They are not granting. Where is that?
They have not issued any written.
Then what can be done?
My lord, may observe that
ଛୁଟି ପରେ ଆସୁ
22 ତାରିଖ ଦିନ ଅଛି, ଦେଖୁନାହାନ୍ତି ଟିକେଟ ଟା ଦେଖୁନାହାନ୍ତି 22 ତାରିଖ ଦିନ
କଣ ହବ ଆପଣଙ୍କ ଭିସା ନହେଲେ ଟିକେଟ ର ମୂଲ୍ୟ କଣ?
ସେଇ ତ ଟିକେଟ ଟା
ସେଇଟା ତ କଥା। ତେଣୁ ଭିସା
company-
ପାଇଁ ଯୋଉଟା ଉପଯୋଗୀ ସେଟା ଆପଣ ଦଉନାହାନ୍ତି।
ସିଏ
ମୁଁ
ମୁଁ
ପରମିଶନ ଦେଇ ଦଉଛି, ଆପଣ ଭେକେସନ ରେ ଆମେଣ୍ଡମେଣ୍ଟ ସାଙ୍ଗରେ ଆଣନ୍ତୁ, ଅର୍ଜେନ୍ସି ଯଦି ଅଛି।
22 ତାରିଖ
ମୁଁ କଣ
22 ତାରିଖ
କରିପାରିବି?
ସୋମବାର ଅଛି।
I
ସେ
want
ଏଇ
to-
ପେଜ 45 ଟା ଦେଖୁନାହାନ୍ତି, ସେଟା ଗୋଟେ ରଙ୍ଗ ଇଣ୍ଟରପ୍ରିଟେସନ କରୁଛନ୍ତି। ଏଟା ଆକ୍ଚୁଆଲି ସେ ରିଲେଟେଡ ନୁହଁ। ପେଜ 45
Page 45 is a guideline.
ହଁ ସେଇ ଗାଇଡଲାଇନ ରେ
Sorry.
କ୍ଲଜ
Can
ସି
you give
ଟାକୁ
a foundation? You say your visa has been rejected, turned down rather. If it is turned down, where is that order? What is impugned here?
ସେମାନେ ରିଟିନ
No, verbal challenge of a visa turning down cannot be entertained. What do you want?
my lord, what I beg to submit before Lordship, pursuant to Lordship's order, they have granted the passport for period till 1st December 2023.
That's all right. Yes.
Now they are saying that unless a fresh order is received by us,
Where is that?
they are not. They have not issued any written communication.
खाली issue notice कर दो। Yes. यदि anchor appearance टा note कर दो central council ले time होला। Yes. You take notice because you will not get any outcome, Mr. Mahapatra, I tell you.
written ତ ନହେଲେ ତ ହବା କଥା ନୁହଁ।
Better withdraw କରନ୍ତୁ, cause of action ରେ ଆଣନ୍ତୁ।
My lord, may indicate that during vacation I will move with amendment. Along with amendment.
Not disclose impugned action if any, except a verbal, except a pleading appearing therein. In the rejection of the visa, read cannot be entertained on this pleading unless the refusal order is accompanied therein. Counsel for the petition is permitted to withdraw the writ application, however, with liberty to bring a proper writ petition even in the vacation. Yes, next appearance note kar do ba. Yes, 50.
Item 50.
I filed a memo of appearance, my lord.
Fresh power.
Memo of appearance, my lord. My lord is there. I have filed an appearance memo.
Okay, all right. What is this case?
My lord, I want to go back to the Tahsildar, where I prayed for a permission under section 22, because the Tahsildar, when he refused, he has said that I will be having no other land, but I have land. And again, he said that my income is 2.5 lakh per year.
But this
That
is
also the ADM has found.
This is after appeal exercise is over.
Oh, yes, my lord.
Then how can it be remitted to Tahsildar?
Appellate authority also said that it is 4.5. And again,
Let them take instruction.
Lordship. My lord may remit it to Tahsildar, let him reconsider.
They consider.
My lord friend will probably agree for a reconsideration by the Tahsildar, taking into account.
Interference is there. Unless interference is there.
That's whatever.
So therefore take notice.
My lord.
Fixing short returnable date. Yes, you find out if there is a case of remand.
My lord,
He
I'll
says
find out.
you have properties there.
Other property there, income is also higher side.
Was it not disclosed?
Yes.
No, there has been a report that was presented before the
That
Tahsildar.
report is not correctly there, so I have also annexed the ROR.
So that therefore adjudication is necessary.
Necessary, my lord.
Okay.
Gotcha.
Place this matter after vacation for the first week of July.
My lord.
You take instruction in the
Extra
meantime.
copy.
Gotcha.
And if You can take into account his submission that he has other properties and the report is otherwise.
Lordship.
If you advise them for a further report, then that may help you and help him both.
Lordship.
Oh, bless.
Next.
Item 51.
Extra copies by tomorrow. They
Yes, yes.
Yes, 51.
Please. Please.
For first content.
First content. 51 already complied.
Complied.
Yes, I have given.
Compliance report. by-
Only the 10-day time required to issue ROR.
Compliance report. filed.
Order he ROR.
However, there is a request by the contender to grant at least 2 weeks time for preparation and issuing the ROR.
Already order he ROR.
Okay, this would consider genuine prayer by the contender. And thus, in the disposal of the contempt, direct permit the contender 2 weeks time to bring out the corrected ROR.
Item 52.
52 also complied.
Lordship, demarcation is copy the. Here also there is filing of complaints which is kept on record. Keeping in view the compliance report, there is nothing survived to be adjudicated. Proceeding according to the. Yes, I'll only take up this 53 and rise. 53, come in.
Item 53.
Arrow matters, so yes, I make it clear after vacation, all those matters will come.
Corrects.
54 onwards.
Correction, only correction my.
Correction आपको order stick रहंतु.
54 notice in matters IA, notice for
54 आसु छुट्टी परे.
notice for substitution in I number 16 of 2022 be issued matters.
Notice has to be.
Notice has to come. Opposite part number, contesting opposite part number 1 die.
Okay, 54 there is application for substitution of copy 1.
Copy 1.
It was 16 of 23. This go direct issue notice to the LRs of the OP. Requisites as undertaken by tomorrow. Interim order अच्छी कीजिए.
No. Interim order read petition है. Read petition है interim order continue.
हाँ, read to interim order continue करेगा. Okay. Just 1 minute. बसंत आपने ये इटा record कर दिया तापरे बाकी तो orders से अच्छी ना. Orders. Yes, what is the development?
Lordship, I have filed a OL report.
My lord, 55, I have filed the IA, my lord.
Just 1 minute, 1 minute, 1 minute. Wait for your turn. Yes.
Lordship, I have filed a report today. The status is like, Lordship, whatever was the records reconciled with PF department, I have issued dividend notices to all. My lord, we like to see para 8, page 3 of my report, Lordship.
Yes.
The illustration is already given, Lordship.
Adjudicated 4495.
Yes, Lordship. This is the total number of claim, Lordship.
Okay, reconciled with PF department also 392.
3922, all issued, Lordship.
Okay.
139 not reconciled. Yesterday, 7:30 PM, we have received a report from PF department. So that has to be reconciled. Actually, the address, name, and father's name I have requested to provide. So what they have provided is a PF form. From that, we have to extract the addresses of 139 people. It will take a day or two for those 139 people. So I'll be in a condition to complete this also.
So by next date, this will be.
Yeah, yes, Lordship. Definitely, Lordship. Only one, my prayer is, we like to see 8E, Lordship. There are 431 number of workmen whose.
No PF due details available.
No, actually the PF numbers are, PF department has not given the details, Lordship.
Not given.
Lordship. But their claims have been adjudicated. I have gone through the claims. There are two categories of mostly people in this. One are like casual laborers who were working on daily basis. And their, my lord might like to see para 10 of my report. I have exactly stated that with regard to
431.
Whose details have not been provided by EPFO, but their claims have been received and adjudicated. It appears that there may be casual laborers who worked on daily basis and or retired workmen.
No order is required here.
No, Lordship. I just want to adjudicate there.
You have already adjudicated. And
yes, Lordship. We have to give the. We just want to disburse this, Lordship, because that has been corrected by our chartered accountant also.
Release that.
Lordship, with the muster roll of the company. And Lordship, the PF department, you have already paid 20 crores 30 lakhs. Till date,
already handed over.
Yes, Lordship. On 4th of May, we have just while RTGS, we have deposited the amount in their account.
Okay, all right.
And till date, Lordship,
2760 number of workmen have been paid, approximately 73.51 crores. Para 7 of my report, Lordship, page 3.
Yes.
This amount,
Total distributed amount is
73.51 crores approximately.
2760.
Yes, this is what I have.
But total claim is 4495.
Lordship, we issue dividends, and after they just return back the dividend, only then we issue the payment.
in
So we are just
process.
waiting for their
How
dividend.
issues are in process.
Yes, they are in process. So by 10 to 15 days, I'll be able to complete almost everything.
Further status report has been filed by the officer liquidator SEKHAR. Here is the observations therein. This court find there has been substantial development with regard to release of dividends, at least in favor of 2760 number of persons as of now. And what is the number that is in process of consideration?
Lordship, it is 431 plus 139, Lordship.
431 is one.
And 139, which is to be reconciled with PF records, Lordship. These are the only two set of people to whom I have to. Yes, Lordship.
Then there is still a big chunk.
Lordship.
There is still a big chunk not attended.
No, Lordship. We have issued the dividend notices to 431 also. The payment has not been done. The reason is
431.
Yes, and 139 is to be done, Lordship. It is to be done.
So 431 plus 2760, it comes to hardly 32 some odd or 3300.
No, it is 3922, Lordship.
Total is 3922.
3922 reconciled with PF department that we have already issued.
That is notice in notice stage. Some
notice already issued, Lordship. After reconciliation, we have issued the notices. The payment is in process, Lordship.
Majority of persons, dividend notices have already been issued, and necessary formalities shall be complied sooner. The notice aspect is clear. It is also brought to the notice of the court that in terms of order dated 21/4/23, there has been release of a sum of rupees 20 crore, 30 lakhs, 45,640 in the account of the, by way of RTGS, in the account of the EPFO on 4th May 2023. Okay, this court direct to record further development. This court direct the proceeding to be posted on 28th of June. Sorry,
Lordship,
30th of June.
Lordship.
30th. Yes, madam, what do you say?
Okay, Lordship.
What do you say?
Item 55, my lord.
55 टिका अपेक्षा करो. आसो चार. 55 बोले आप और ढोका है just 1 minute. It is 55.
Item 55.
As per your lordship's direction, my lord.
सुबह माइक अगर रों तो.
As per your lordship's direction dated, my lord, 29.
Okay, just
22, my lord.
1785.
Wide annexure 1, my lord. The Tahsildar called the petitioner for demarcation, my lord.
This can wait. This can wait till vacation.
No, my lord. Only very
No, I have
small
no
prayer,
time,
my
madam.
lord.
I am already 10 minutes late.
My lord, only a direction may be given, my lord. Report has not been
It's a
given,
dispose
my
of
lord.
case.
Only,
It's a dispose of case.
yes, my lord. My lord.
What application you have filed now?
My lord, as per your lordship's direction, my lord, the Tahsildar, my lord, OP3 called the petitioner for demarcation, my lord, on 30th/1/2023, my lord, and the petitioner was also present. Tahsildar with all his personnel came, my lord.
It's a dispose of case. What?
Yes, my lord.
What you allege? What you allege? You allege the Tahsildar is not working out the direction.
No, my lord. He has done the demarcation, my lord. Report has not been.
Pardon? Recovery.
Report has not been given, my lord, from last January to till today.
Okay, why are you not giving the report? Demarcation report. If you have completed, if you have completed, communicate the outcome.
Yes, yes, my lord.
Through the miscase, it has been alleged, even though demarcation aspect has been completed in terms of disposal direction herein, but no report has been prepared or either been prepared nor supplied to the parties involved in considering innocuous prayer And as this court find the requisition already disposed. In the disposal of IA, this court observe, provided there is preparation of report dependent on the demarcation exercise. Copy of outcome will be supplied to the respective parties on their filing. On their filing copy application for certified copy of the yes, next.
Next matter, in the ordering portion, yeah, the writ petition number has been wrongly mentioned.
Portion
Front page of order re. Front page order re.
OJC hoba kata.
No. WPC number 14880 case number ta, kintu seta wrongly type he jaiche 14480.
Okay, actually.
Order front page re, top re.
Oh, 14880.
00 ହେଇଛି
Sorry.
ଏବଂ paragraph 5 ର appearance date ଟା 26th May 23 କହିଥିଲେ ଏଟା February type ହେଇଯାଇଛି para 5 ର 10th line ରେ 26th February 23 May ସେଟା ଆପଣ ଡାକିଲେ ଯେ ଆମେ appear କରିବୁ this court permits the petition to bring their objection to the notice filed annex of 3 next
dita case ଅଛି
आर केस ର କେବଳ ସେ 26th May କିନ୍ତୁ କେସ୍ ନମ୍ବର ଟା ସେଥିରେ ଠିକ ଲେଖା ହେଇଛି
ଖାଲି para 5 ର ହବ
ଖାଲି para 5 ରେ 26th May
ହେଲା at the top case number ଟା wrongly ହେଇଯାଇଛି ଆଉ date ଟା May ହବ ଆରଟାରେ ଖାଲି May ହବ
obligation